Hey, folks, we are returning to, well, Norfolk County, Massachusetts, also known as where Canton is. We are going to listen to Mr. Lally, who is a prosecutor in Norfolk County. He was the one trying to prosecute and convict Ken Reed. This here is the case with more of the same actors, with Proctor and a lot the investigators, many who now are retired, were transferred out, fired, and yeah. So this is Myles King. He is accused of redrum. Have to be careful. Apparently, YouTube is very, very keen on only allowing news organizations covering things that involves words like redrum and self-ending and stuff like that. Now, this is a pure redrum case from 2021. Mr. King has been in jail for quite some time now. And this is a hearing on the defense motion to dismiss. Mr. King's attorney is Rosemary Scapicchio. And she is always on fire. And today, apparently, wasn't an exception. So, folks, I mean, what can I say other than welcome to the show.
Santa Claus, riding in with the winter laws. Santa Claus, streaming live for the roaring masses. Ho, 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 raise them horns, old Judge King in a crown of thorns. Santa Claus, streaming live.
Okay, folks. There was a few live streaming this, and some of them were, let's just say, cluttering the. Well, the screen was not empty. Let's just say that. So, thank you to Young Jerks for live streaming this. Good numbers for you. Good on you. But I'm using new stream, and here we go.
There have been quite a number of additional disclosures. There have been supplemental motions to dismiss filed, two of them, as far as I can tell, one purporting to describe certain prejudice from the late disclosures, and one on a different grounds relating to Michael Proctor. And so when we spoke last time, I think I talked about being able to opine myself in advance of which witnesses we would be calling. I saw that stuff was recently filed, and I saw it too late to make that call, nor do I think I would be very good at making that call based on what's been presented to me. This is really two prongs: late disclosure and any prejudice from that late disclosure. So those are two prongs of the same issue.
Yes, sir.
And number two, bias in the investigation as a result of Mr. Proctor's strongly held views and strongly articulated views.
Yeah, that is a very, very lawyery way to say it. That it's now well known through filings and everything that Trooper Proctor is a very vocal, almost very vocal publicly, considering how many he told all these things. fan of a certain Austrian painter that was very, very famous in the late 1930s and early 1940s. Let's just say that. And hi, Pam. Is Myles going to get away with Red Rum? Well, it's a possibility or a risk. But don't get mad at Myles or Miss Scapicchio. It is on the choosing of the prosecution and the investigators that Myles King, innocent until proven otherwise in a court of law, but damn, the evidence is strong, that it might suppress a lot of evidence, Proctor's and Lally's actions. It might even, at the far end of it, I don't believe so, but it might be thrown out. It might be. Don't know, but it might, because of their actions.
And I wanted to hear from you as to what we should do next. It seems to me we have to finish Mr. Lally's testimony. I have a full afternoon, unfortunately, so we have all morning. We have until 1 o'clock. But hopefully we can get Mr. Lally finished today. And then we can have further discussion about whether there is any evidence needed on the second supplemental motion relating to Mr. Proctor, and what additional witnesses we need with respect to the first issue. Yes. So I'm only saying this because it's like speaking out loud. I'm trying to frame the issue as best as I understand it. So anybody who wants to tweak that understanding, I'm welcome to. I'd be welcome to hear from you.
So Judge, I guess I had a question regarding the additional witnesses. Does the court want to hear argument on that, or are we going to be allowed to call them, or are you going to decide witness by witness?
I think we should hear what it is that you're and why they're being called. Okay. Yes, we should have that conversation, but I got a 1-paragraph description. Maybe that's all I asked for about what they.
1-paragraph description per witness.
And, I appreciate that. And it helped you each think about whether that person should be called, but I'm not sure that I could flesh it out enough. Okay. So,
spoiler. Adam Lally was the only witness the entire day. They didn't get to anybody else. So there will be follow-up hearings on this.
I'm guilty of my own inventiveness. So you want to start with Mr. Lally and see if we can get Mr. Lally on and off the stand, and then we can have further conversations?
Sure, Your Honor.
Okay, he's testifying as to the first part of the motion, the issue of
I don't know if it's limited.
Timing of disclosure and potential prejudice.
I don't know if it's limited to the first part of the disclosure, because he worked with Trooper Proctor, so I'd be asking him questions regarding Trooper Proctor as well, Judge.
All right, we can take those up if there's an objection. Okay?
Sure, Your Honor.
Okay. We can recall Attorney Lally.
Oh, Judge, can I ask one question?
Sure.
My client has handcuffs on him, and I spoke to the court officers. I'm wondering if the court would authorize him to have the handcuffs undone for the purposes of this hearing so he can take notes.
That's okay.
Thank you, Your Honor. For him to take off the handcuffs. Thank you, Your Honor. I appreciate it.
Mm-hmm.
All right.
So Lally, we started your testimony in the other room back in July of 2025. You were sworn at that time. Yes. And I'm going to remind you, for purposes of this hearing, you're still under oath, okay?
Absolutely. Still under oath.
Yeah, Your Honor.
Not that he becomes less evasive with sworn in.
You may.
Thank you.
You can be seated if you want.
Yes, sit down.
Morning, Mr. Lally.
Morning.
So last we spoke, we were talking about your involvement in Mr. King's case as the assigned assistant district attorney. Do you remember that testimony?
Yes.
Okay. The testimony has been transcribed. All of the parties have it. So I'm not going to go over any of that testimony. I think we're going to move on to issues that are relevant to this hearing. The first thing I want to talk to you about is, I'm not sure if we have Exhibit 1 or if we need a new copy of Exhibit 1. Did a new copy? We have it, or we need a new copy. Let's talk to Mr. Lally about it. May I put you in?
Sure.
This is just a motion.
Just a reminder for the algo, be active in chat, leave a thumbs up, subscribe if you haven't. I know everybody says it, but it actually helps if somebody reminds you guys over it. Thank you. Yes, over a year later, the hearing continues. Yeah, and this isn't the last hearing. I mean, Adam Lally, a few hours last year, and now the entire morning.
I'm showing you a document, Attorney Dallas. Can you tell me whether or not you recognize that document?
I believe so, yes.
Okay. And does that give me the discovery motion that I filed with the state?
It appears to be yes.
If I can just, what's the date of that document?
I was going to do, Judge. 12/22/21.
Okay.
I move to introduce the judge.
It may have been marked as Exhibit 1 before, right? Everybody thinks this is what was marked as Exhibit 1?
Yes.
All right, so we'll remark that as Exhibit 1.
So, Mr. Lally, when you received that from me in December of 2021, what did you do?
I did what I do with any discovery motion that I received from counsel, and I forwarded to all involved police departments in the case and make requests basically to fulfill whatever you or any other counsel is looking for in terms of discovery.
So in this case, who'd you forward it to?
In this case, I would have forwarded it to probably Trooper Proctor as the case officer and Lieutenant Collins from Milton PD.
So to the state police and to the Milton Police Department, is that right?
Yes, I mean,
Would you have forwarded it to anyone else?
Hold on, let him finish.
I'm sorry, Judge.
No, all I was going to say is potentially someone else, depending on the content. I don't recall if it had something to do with the lab or the medical examiner's office or something, some other agency, then I would have forwarded to that agency as well.
And then once you forwarded my discovery request to at least the state police and the Milton police, what did you do to follow up on that?
If there were materials that were discoverable within the motion and I hadn't received them, then I would have followed up to find out what the status was or what was going on with those particular items.
So wait a minute, who's making the determinations as to what's discoverable? Is that the state police and the Milton Police Department, based on you sending them the motion?
Discoverable is a wrong term. What I meant to say was whether or not they had them in their possession, whether or not it was something that they had in their custody and control, because there certainly could be requests made within a discovery motion for items that just either don't exist or we don't have.
Yeah, we learned that last year, that Proctor didn't even bother to reply when Lally sent, hey, do you have this? This is supposed to be there. Send it over. And Proctor couldn't be bothered. And Lally couldn't be bothered either. So have that in mind when Lally says these things that we've already heard him testify, that he never followed up. Never, never, never. Because he trusted that the officers, the investigators, did as the followed the Rule 14 on automatic discovery. Now, this, in my opinion, is called plausible deniability. This is the Norfolk District Attorney's Office, who lets the officers know that unless you say anything and we won't ask about it, that leaves us both with plausible deniability as to responsibility of the absolute screw-ups that happens in the Norfolk District Attorney's Office. And it's worked. For many, many years, the entirety of Adam Lally's career as a career prosecutor, which was in 2021, it was 16 years. So as of now, 21 years. This is how he works. He passes on, yeah, we have a new case. You're supposed to send over all the discovery. And then he ignores everything.
When you sent this to let's start with the state police. When you sent it to the state police and you said Trooper Proctor, what response did you get from Trooper Proctor back in December of 2021 about the documents that would fulfill my discovery request?
I couldn't tell you.
Well, do you have any notes, or did you take any notes at the time about what Trooper Proctor represented to you that was in the file that needed to be disclosed?
If I did, I have not looked at notes or anything pertaining to the file.
That was his exact same answer a year ago. He knew what this hearing was about. And he does not check his paperwork. Why? Plausible deniability. Whoopsie. Oh, was I supposed to check my notes for a hearing on a motion to dismiss? No. I'm just a career prosecutor. I don't do that.
File in a very long time. I'm trying to answer your question, but I don't know.
So you didn't look at the file before you came here and testified today?
No.
You knew we were going to ask about the file, right?
I don't know what you're going to ask about.
Well, we asked about the file a year ago, right?
Yes.
And I asked you to review it then a year ago. Do you remember that?
I don't remember you saying that, but sure.
And then you knew you were going to be in here and be questioned about the file, right?
I don't know what you're going to ask me.
When we're talking about late discovery, do you think that the file that's contained in the district attorney's office is important to determine what was disclosed and what wasn't, Attorney Lally?
I'm sorry, what is your question?
When you're talking about late discovery, do you think what's contained in the district attorney's file is important to determine what was disclosed and what wasn't disclosed?
Certainly.
And you didn't do anything to look at that file, is that what you're saying?
To look at notes from December of 21? No, I didn't.
All right, how about your memory? What's your memory of what Trooper Proctor told you he had in terms of documents?
My memory and again, I mean, it's an ongoing obligation to provide discovery. So as the case moves along and more
He hasn't gotten on yet, we're just talking about...
Hold on, he's not done.
Sorry.
So recognizing that there's an ongoing obligation to provide discovery, if there's any discovery that is generated, then it would be provided in the time that it was, as I did with the 26 notices of discovery and the 172 items of unique discovery that was provided to you over the course of the time that I was handling the case.
Oh, so you knew about those numbers, you just don't know about the file, right?
As far as...
I don't know what you're referring to as the file.
The file in the district attorney's office that would have the information of what notes he took during the time that he represented the Commonwealth.
Okay.
He told us he kept a checklist.
This is not a jury trial, right? This is a hearing in front of the court. Okay. He did not review the file before coming in today. Next question.
May I be heard, Your Honor?
Yes.
Mr. Lally's been sequestered since last year. Additionally, he's not the prosecutor.
With an exception provided by me on request. Okay? I understand that.
Thanks.
Go ahead.
So, what did Trooper Proctor give you?
Specific to this motion?
Yes.
I don't recall it's a 10-page motion. I don't recall everything that was listed within the motion.
If he was going to give you anything, when you got it in your office, how did you document it?
I'm sorry, how did I document what was provided?
Yes.
In the notice of discovery that was provided to you.
So the notice that was the discovery that was provided to me, That's the way you documented what the state police gave you? Is that right?
But as soon as I receive anything, as far as discovery is concerned, I don't wait for the next court date to turn it over. What I do is, as soon as I receive something, I make a copy of it, I forward it to counsel along with the notice of discovery and the cover letter attached to it.
So, but my question was, the notice of discovery that you provided in this case, and you said you provided 26 notices of discovery, that discovery came from Trooper Proctor, right?
Not all of it. I mean, there were items from other agencies, but anything from the state police presumably would have come from him.
From Trooper Proctor?
Correct.
Okay. And so my question to you is, when you get whatever you get, so how does Trooper Proctor give it to you? Does he email it? Does he drop it off? Do you have a conversation? How does that happen?
It varies depending on what it is. It could be any one of those things.
Okay. So do you know how many times you met with Trooper Proctor regarding this case and the discovery?
No.
And can you tell me when he sends discovery to you, whether it's by email or he drops it off or you have a conversation, how do you document that in your file?
I don't think I would necessarily document that I received a certain item on a certain day. Again,
How do you not? This type of answer, if it is correct, is mind-boggling to me. Now, in my area of law, which is labor and employment, I would get reamed out and fired if my note-taking of, okay, now we get this, now we get this, now we get this, we have to send this, 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 and this. If I wasn't taking notes, documenting meticulously, I would be fired in an instant. It's mind-boggling to me that this career prosecutor with a severely high salary seems to sit on his ass and do jack shit just so he can avoid accountability if something goes wrong. Yeah, as Chelsea says, this is weaponized incompetence and a regular tactic of the state of Massachusetts. It's insanity. Imagine if a defense attorney did this. Imagine it would be a bar complaint. But it's a prosecutor. Different standards.
As soon as I receive it, what I do with it before the end of the day is I type up a notice of discovery, I make a copy of whatever the discovery item is, and I would then send it off to defense counsel.
Okay. And did you do the same thing with the Milton Police Department? You sent the motion to the Milton Police Department, is that right?
Yes.
And how would you communicate with the Milton Police Department about that, about documents that they have responsive to that discovery request?
In the same manner, as far as whether I couldn't tell you if it was a phone call or an email, but it was, I mean, as far as forwarding the discovery motion to them, that was done via email. But as far as, any subsequent conversations in relation to it, essentially what I'm looking for from every department in every case that I've ever done is anything and everything that you have.
Let me say this. Adam Lally, when he still was lead prosecutor for this case, back in 2022, I mean, at the early stages of this, claimed repeatedly to the court that all or almost all of the discovery have been handed over. Repeatedly. And it was, to this day, all the discovery has not been turned over. To this day, almost 5 years later, all the discovery. And folks, remember the Karen Reed case? We are still, to this day, after she was acquitted, we find out new things that the prosecution hid from the defense. And this case, and the Karen Reed case, highly publicized. Imagine the rest of his 21-year career as a prosecutor in cases that wasn't publicized, where the defendant did not have a Giannetti, did not have a Scapicchio as defense attorney. How many times has his weaponized incompetence put people in prison that shouldn't be there? His entire career.
And do you tell them that? This motion asks specific things, but I want anything and everything that you have. Did you say that to the Milton Police, sir?
Yes.
And did you say it to the state police, sir?
Yes.
Okay. And then did you keep track? I think you said last time you had a checklist of what was turned over and what was still outstanding. That was something you kept in your file. Is that right?
I'm not sure what checklist you're talking about.
Well, you talked about a checklist last time we testified. You said the way you kept track of things is that you had a checklist, and when things were turned over, you would check it off. Remember that testimony?
I don't.
You know, is that what you did? Did you have a checklist?
So I would have a checklist when I first get assigned to the case as far as items that I'm looking for purposes of grand jury and for purposes of general discovery, because my intention is always to sort of front load the discovery and give counsel as much as humanly possible at the arraignment date. Subsequent to the arraignment date, if there was something specific that was either requested by counsel or there was a motion filed, then yes, I mean, I would keep that or do my best to keep track of, you know, what was outstanding and what we were looking for.
And was that by checklist like you talked about before?
So the checklist thing I think you're talking about is probably something that I do prior to indictment. So a checklist is sort of initially when I receive the file, then I'm going through it and trying to figure out, you know, what do we have in this case as far as evidence is concerned? Is there video? Is there photos? Is there some sort of grand jury subpoena for third-party records I need to do or what have you?
So with respect to let's start with the state police. When you receive the documents from the state police, you immediately put together a discovery notice and send it out. Is that right?
Correct.
And the same thing with the Milton police, is that right?
Correct.
All right. And then at some point, I assume you looked through what they gave you, right, before you sent it out?
Well, I would, yes, review things before providing them to anybody, sure.
Okay. And did you make any determinations that anything that the state police gave you was not discoverable?
No.
Did you make any determinations that anything the Milton police gave you was not discoverable?
No. And to be honest, I don't think I've ever looked at any piece of discovery and said, I'm not going to give this to the defense attorney because I don't think it's discoverable. That I don't do. I don't make those calls. I think that's something for the court.
Well, you have to determine what's discoverable because you have to turn it over, right?
Correct. But what I'm saying is if I receive discovery, you as a defense attorney are getting it, whether, you know, we could argue later on whether or not it's admissible, but as far as you having access to it, you should have access to everything that I have.
And this goes back to plausible deniability. This, the investigators know, the corrupt investigators know, so they don't hand it over to him, knowing that he can always say, well, I handed over what I got. So they keep themselves a few steps behind Lally because now they know Lally will just send the things over. He doesn't care if the investigators are lying to him or hiding things. He barely checks it to see, does this comply to the actual motion? Which we know he didn't check. Is the information in this motion, is this actually in here? He will not check it. He just sends it over. And the kind of stalling tactics, because now they buy themselves another few weeks, a month or two, while the defense goes through the discovery. And, oh, we didn't get this. Then they file back. Stalling tactics. And it's infuriating how the Norfolk District Attorney's Office wastes everybody's time in every case, it seems, involving ADA Lally.
Okay. So once you do the first round of discovery, did you believe that discovery was complete at that point, that the state police had complied with everything that I requested?
Yes.
You did.
How did you know?
As far as what existed at that time, I'm sure there were things in your motion that might become, whether it was forensic testing or things of that nature that, but as far as reports were concerned, everything that I had, you had. If there was going to be anything further, reports written or forensic testing that was conducted, then that would be provided as soon as we received it.
So it's your position that the first round of discovery, Discovery 1, contained all the information that the state police had up to the date that you disclosed that information. Is that right?
That's my understanding, yes.
And what about the Milton Police Department? When you sent them the motion, is that the same thing? What they turned over to you was everything that they had?
That was my understanding, yes.
I want to be very clear about what your testimony is, Mr. Lally. Is it your testimony that as of the first disclosure, you had disclosed everything that you had or everything that the state police had?
So in the first disclosure, it would have been every single thing that I had. And if there was...
I don't like that the judge is allowed to ask his own questions. But this, in my opinion, is not a question for the judge to ask. That is something for the state to try to correct on cross-examination. So I'm not a fan of that question.
I believe this motion is dated in December of 21, which was, I believe, around the time that Mr. King was arraigned in this court. So then that would have been post-indictment, post his arraignment, then that would have been forwarded to the relevant police departments and a request made to, any and all materials that are contained within the motion or any other materials that the departments have, I need.
So let's continue about the Milton Police Department. So it's your position that when Milton responded to you in the first discovery motion, they gave you everything that they had generated through the date of that disclosure. Is that right?
That's my understanding, yes.
Okay. Did you do anything to make sure that you got everything from the Milton Police Department?
Do anything further than ask for everything and been told that I had everything? No.
Well, let's stop there. Who told you you had everything from Milton? Who said you have everything we have? Who said that?
That would have been Lieutenant Collins.
Lieutenant Collins. So you had a conversation.
Now he's throwing officers under the bus. Yeah, he told me I got everything. Okay, great. That's a sworn testimony that can be used when it's time for Mr. Collins to take the stand. And if Collins says, no, that's not true, then there might be an issue. But we will not find out. We will not find that out today, because today Adam Lally was on the stand the entire day.
Conversation with Lieutenant Collins sometimes before you filed the first discovery notice, in which he told you have every document that we produced in this case through today's date. Is that what happened?
Yes.
Okay. And did you at that point say, let me see your file?
I did not, no.
Is there a reason you didn't ask to see the file?
I accepted his representation that I had everything that he had.
Okay. And you found out later that that wasn't true, right?
Correct.
So I guess my question is when...
So if it appears that Adam Lally trusts the investigators when they tell him, oh, we've sent you everything, because he never actually checks if did they comply with this motion. He just doesn't do that for plausible deniability. But here he is throwing the investigators under the bus. I don't mind it, but it's a waste of fucking time. Absolute waste of time to hear him sit there admitting to everyone who's listening that he's basically a secretary between the investigators and the defense. Yeah, they give me that and I just send it along. I don't check anything. I don't check if it complies, to save time, because had an ethical prosecutor when with the question, is this everything? And the investigator says, yes. He's still, an ethical prosecutor would have checked the material. Well, that's missing, that's missing, that's missing, that's missing. Call back. Hey, where's that, and that? And then he could have gotten the answer, we don't have it yet. It's still being processed, yada, yada, yada. And then you would have a clear answer that you then can, okay, we are complying to these parts of this discovery motion because that, and that is not yet processed. That is what an ethical prosecutor would have done. Adam Lally, he is a glorified filing cabinet. He has the use and worth of a filing cabinet.
And a police department tells you that they've given you everything, and you take that at face value that they've given you everything. Is there any follow-up at all to say, let me see your whole box, let me see all your stuff, send me your electronic file, anything like that?
At that time, no.
Okay. So I guess the question is, how can you represent to the court that you've turned everything over? You're relying on the individual police departments to tell you that they gave you everything?
At that time in the case, yes.
Okay. So are they the ones that are looking at the discovery motion saying these are the things that Ping is asking for and these are the things we have to disclose, or are you saying give me everything?
Both. I'm giving them a copy of the motion so they can know specifically what you've requested. And then I'm also, at the same time, telling them to give me anything and everything, even if it's not encompassed within your motion.
Okay. So, I'm sorry, Judge. Did you?
No? Go ahead.
Okay. So you're doing both. You're saying you have an obligation to turn over all the reports, so you want everything. And then you're also showing them the motion saying this is what has been specifically requested, right?
Correct.
Because despite what's specifically requested, there's a Rule 14 obligation for you to turn over discovery, right?
Yes.
And discovery certainly encompasses police reports, is that right?
Yes.
And grand jury testimony, is that right?
Yes.
And any type of scientific testing, is that right?
Yes.
Witness statements, is that right?
Yes.
Okay. And in this case, from the Milton Police Department, who was it that told you that you had everything?
I'm assuming it's Lieutenant Collins. He was my primary contact with the Milton Police during that time.
So when Lieutenant Collins told you that you had everything, you relied on Lieutenant Collins' representation that he had given you all of the reports, all of the interviews, all of the materials that were contained in his file. Is that right?
Yes.
And you never did any follow-up to find out whether or not that was true. Is that right?
No.
All right. So when do you do the follow-up to find out if you have everything? Because you filed 26 discovery motions in this case, right?
Notices of discovery, yes.
Okay.
Yeah, 26 notices of discovery about things that was missing. And not once did ADA, Adam Lally, I mean, first notice, okay, something's happening. Hey, asswipe in that department, you are making me look like a fool. Do not do this. Explain to me why this crap is not in here. And hand it the fuck over. So I can hand it the fuck over. You would imagine that by notice number 4 and it's still missing shit, you would be furious at this local cop who keeps hiding things. No, not Lally. Not even after 20 fucking 6 notices does he care. 26 notices, for the love of fuck. For the absolute love of fuck. This is why I hate this idea about that prosecutors need immunity for fuck-ups. Because that immunity creates Adam Lallies who just don't care. Who weaponizes incompetence. Who weaponizes plausible deniability. This here is a direct result of that.
26 notices of discovery, we still didn't get all the reports from Milton. Is that fair to say?
That's my understanding now, yes.
So how did that happen? What happened there?
How does that happen?
Yes.
I couldn't tell you.
So at any point in time before filing these 26 discovery motions, do you make arrangements to go down to the Milton Police Department and look through their files?
No.
At any point in time while you were the assigned assistant district attorney in this case, did you go down to the Milton Police Department and look through their file?
No, because normally that is something that I do when a case gets a trial date.
When the case gets to trial?
No, not when the case gets to trial. When the case gets the trial date, I would then meet with each of the individual officers and make sure that there's nothing that they have that I don't.
Okay. And so do you do that on the day that the trial date is assigned, or you do it closer in time to when the trial actually is going to happen?
It depends. Depends on the case, depends on the complexity, depends on how many witnesses, depends on how much time would be necessary to prepare for trial.
Depends on how much you want to keep from the defense. You forgot to say that.
So what happens when you finally do this review of their file and you find documents that haven't been disclosed? What happens then?
And that would be something that I would immediately turn over to counsel.
And what if it's on the eve of trial?
It would not be on the eve of trial. I don't meet with witnesses. I don't wait to meet with witnesses until the eve of trial.
What did you wait for in this case? How long did you wait?
This case didn't have a trial date when I...
Oh, it did. It had a trial.
It had a trial date, I think, 8 months after the fact, but it was also 8 months from the date when it was reassigned to Ms. Hickman.
When it was reassigned to Attorney Hickman, is that what you say?
Yes.
Okay. So it's your practice within the Norfolk County District Attorney's Office to ask for the individual police departments to give you everything and to send them the motion, but to not do any follow-up until there's a trial date. Is that right?
I wouldn't say that there's no follow-up. There were subsequent motions that you filed that, again, same practice as far as copying the motion and sending it to them. If there was anything that I became aware of that may exist, obviously I would follow up on that. But as far as when I ask them for everything and I get a representation that I have everything that they have, I assume that I have everything that they have.
I guess it's the assumption that I'm having a little bit of difficulty with. So instead of assuming, do you ever take it upon yourself to go look at the file?
We're talking about in this case?
In this case, yes.
Did you go down and look at the file yourself?
In this case, no.
And is there a reason for that?
No.
Because you want...
Is there a reason? Oh, so he had the case from late 2021 to either late 2024 or early 2025, and not once did he lift his fat ass from his comfy chair to get his ass down to a precinct to look at any type of evidence. Not once.
It was your obligation to make sure that Mr. King got all of the discovery that he was entitled to, right?
Correct. Well, I mean, as far as the reason for that would be that I asked for everything and was told that I have everything. So I didn't feel the need to go down and look through the file myself to see if it was...
26 notices that shit was missing, and you did nothing because you didn't see a reason? I mean, yeah.
Anything beyond that.
Were you ever trained within the Norfolk County District Attorney's Office to do your own searching through these files, to not rely on individual police departments to turn over discovery to you? Did anyone ever tell you that during training, that would probably be a good idea?
Not that I can recall, no.
Okay. And by the time you had Mr. King's case, how many years had you been an assistant district attorney?
By the time I was assigned Mr. King's case, probably 16 years.
So for 16 years, your practice was that you relied on the individual police departments to give you everything. And if you didn't get it, you waited until it's right before the trial to look through the trial file. Is that what you do? You look through the file right before trial?
No, not right before trial. That's, I think, that's not what I said.
Okay. But your practice is to rely on the police departments, individual police departments, to give you all of the discovery. Is that right?
Yes.
Your practice isn't to go to the individual police departments and look at their files, right?
At the point in time you're talking about, and when just after the defendant's been arraigned, no.
How about in the 26 notices that you filed? Before any of the 26 notices that you filed, did you go to the Milton Police Department and make sure you had everything?
No.
How about the state police and the 26 notices that you filed? Did you go to the state police to make sure you had anything?
Probably, yes, yeah.
You probably went to the state police.
Yes.
What does that mean?
What that means is, again, as a case is going on for the number of months that this case went on, there were, I would imagine, numerous conversations regarding discovery, whether it was a motion that you had filed or whether it was a motion that I had filed or different aspects of discovery that we were looking at. And those conversations would have been ongoing as far as, you know, ensuring that I had everything. That it's not like I would rely on a one-time representation at the inception of the case. Do I have everything? Yes. Okay, fine.
So I guess my question is, with respect to the state police, did you ever go and look at their files? While you represented the Commonwealth in the case of Commonwealth versus Myles King, did you go and look at the state police file?
No.
Did you have any idea in the 26 notices of discovery that you filed what the contents of the state police file was?
No.
What about the Milton?
26 notices, and he never checked the file even once.
Police in the 26 notices of discovery that you filed, did you ever have any idea what was contained in the Milton police file?
No, other than what I've been told, that I had everything they had.
Okay. In terms of discovery, so let's talk about police reports. So all of these police reports that are generated in 2025 by the Milton Police Department after ADA Hickman went and actually looked at the files, you understand that there was a number of police reports dated on the date of the incident or shortly thereafter that were never turned over to the defense. You understand that, right?
My understanding was one.
You only knew that there was one.
That was my understanding, yes.
So you thought there was one police report missing from Milton, not a bunch of police reports that ADA Hickman turned up when she actually went through the file.
My understanding is as far as police reports, there was one.
What about documents? How many documents did ADA Hickman copy and turn over to?
Yeah, at least ADA Hickman, when she took over, at least she has an iota of ethical responsibility, or feels an iota of ethical responsibility. Because it seems like, at least for now, that if she wants to win by the rules. So she handed all of this over, and cluster F ensued. But Alan Lally still works there, still works cases, still doing his thing. 21 years after his first day as an ADA, this is what he does. He's a glorified filing cabinet.
The defendant after she reviewed the Milton files, you know?
I don't.
Did anyone ever go back to you and ask you why?
That's a good point. Yeah. Ambisens. We know he didn't meet with Sully in the Karen retrial until after opening statements. That's a great point. Counteracting what Lally says. Well, he never waited until eve of trial. Well, we know that's a lie. Thank you.
These weren't turned over to the defendant?
No.
Did you ever talk to ADA Hickman and try to explain why these weren't turned over to the defendant?
As far as the why, no. I mean, the why is obvious. I wasn't aware of them, so they weren't turned over.
Okay, so why weren't you aware of them? Didn't anyone ask you that? How were you not aware of these reports?
No.
Nobody from the district attorney's office asked you why you weren't aware of these reports?
Objection. Sustained.
Did Attorney Hickman ask you why you weren't aware of these reports?
Objection. Sustained.
In any event, the reports get turned over in 2025, and you think it's one report that gets turned over in 2025. Is that your understanding of the late disclosures in this case?
My understanding as far as the police report, yes.
Were there other documents that were, to your knowledge, taken from the Milton file that weren't turned over?
Your Honor,
Yes.
may I be heard?
You may be heard.
There's been a number of notices of discovery that speak for themselves, and ADA Lally was not the prosecutor after December of 2025.
Right. I'm not sure I understand the relevance of what he knew about later disclosures by others.
Because
How is that not relevant? These are late discovery that should have been handed over when he was prosecuting this case. So, yeah, absolutely, this is relevant.
he said there was one document, Judge. There's way more than one document, so I was going to get there.
But I don't understand what his knowledge in 2025 of later disclosures, how that's relevant to the question of why that stuff wasn't turned over.
Well, because he said it was one document, Judge, and I need to make a record of what was actually turned over by ADA Hickman.
All right, the record already exists in the file of what was turned over.
So are you saying that the court will take the Commonwealth's notice of discovery 28 as evidence in this case, Judge?
I don't see why not. All of these.
So she took a sustained objection and turned it into, well, then I guess the state doesn't mind that we put all of this into evidence in this hearing. That's some good lawyering there. That is some good lawyering. When you can change a sustained objection or relevance into, yeah, okay, then admit it. And Björk says, yeah, okay, here we go.
These notices of discovery are part of the record.
Right.
Additionally, and I'm happy to mark it, I don't want to go off on this tangent. We had those charts. I'm happy to mark the last one that we had prepared together about what's new and
Okay, that wasn't yet marked, but we can deal with
mark
that.
that at
Yep.
some point. Yeah.
So have you ever withdrawn from representing the Commonwealth in this case?
As far as a formal motion, no.
So you're still an attorney of record, right?
No, I don't believe I'm on the docket or listed as counsel of record on.
So when did you withdraw?
Again, did I file a formal motion to withdraw? No, but whether or not, but I'm not counsel of record for the case.
So when did you stop being counsel of record for the Commonwealth?
I believe it was either November or December of 2024.
Of 2024?
I believe either that or early 25.
Okay. But you didn't file a motion to withdraw?
I don't believe so, no.
And you showed up at all the hearings when you weren't on trial in the Karen Reed matter, right?
During 2024?
24, 25?
25, no. I don't
You didn't
believe.
show up at any of the hearings in 25?
I don't believe I did. I'm not. That's why I said I'm not sure.
Okay. In any event, with respect to the state police, you said you spoke to Trooper Proctor, you asked him for everything, he sent you information, and ultimately you turned that over. Is that right?
Correct.
All right, let's talk about the search warrant. You realize that there were search warrants that were contained in the file dating back to 2021 that weren't turned over, right?
Contained in what file?
I'm sorry?
Contained in what file?
Objection to the form of the question.
Let's have a question from the beginning.
Sure. Can I look at this one?
Yes.
Can you look at these documents and tell me if you recognize them?
Now, Adam Lally has already admitted that he doesn't check what the cops send him. He never does. So even though he knows that warrants should be in discovery, he just doesn't care enough to check if it's actually in there.
Leave the search warrants.
Yeah, 21 search warrants. Is that back to 2022? Yeah. terms of what I saw.
Generally speaking, yeah.
I didn't hear what you said.
Recognize them?
Generally speaking, I recognize them, yes.
Okay.
What do you recognize them to be?
They appear to be search warrants related to Mr. King's matter.
Related to what?
Related to Mr. King's matter.
Okay. And is it fair to say that these search warrant number, let me ask you, is it fair to say that these search warrants appear to be dated July 11th of 2021?
I didn't look at the date, but I'll take your word for it.
And just may I ask, are these the bait stamp search warrants? These all bait stamped in the top right hand corner?
We start at 282,
Thank you.
I believe.
Thank you.
Base stamp 282.
Thank you.
Is
Sorry.
there a motion to introduce the search warrant?
Any objection?
No, no, no.
All right.
How many are there? Oh, 6 warrants in total?
Yes. So Attorney Lally, you understood that there were search warrants in this case, right?
Yes,
And you understood that Trooper Proctor was the author of those search warrants, right?
yes,
And you understood that he asked for certain information. I'm assuming he consulted with you regarding that. Is that right?
as far as the information he was seeking, yes.
Yes. Did he consult with you regarding a T-Mobile search warrant for cell phone number 6961?
I believe that was your client's cell phone, so yes.
Okay. And
Hey, thank you, Derek. Thank you so much. 150 joules. This is something for you who are watching this on mobile. Still don't know what exactly what it is, but I do know it is 150 joules. I did not have 5 minutes ago. So thank you so much, Derek. Thank you, thank you, thank you.
And you understood that he had gotten permission to do a search. Is that right?
There were, I think, 4 warrants pertaining to your client's phone.
So is that a yes? You understood that there were warrants that were signed off on by a district court judge for information in this case, right?
Yes.
Okay. And when you looked at the discovery as it was being sent to you from Trooper Proctor, did you realize you didn't have the search warrants?
No.
Objection to former question. I just want to be clear on,
There is a timing part.
or just what portion of the search warrants. I think the issue is the affidavit.
Well, you can take care of that on cross, can't you?
Let's just be clear about the question. Do you have them there? I haven't seen Exhibit 2. Let me take a look at them.
Thank you.
I mean, this is just ridiculous. I mean,
But Judge, I have an extra copy. You can.
we know he didn't check the material. We know because he admitted to it. So, of course, he didn't know what type of warrant, if it was parts of a warrant. He doesn't know because he doesn't care.
Read along if you want with that copy.
Well, the material that I have here, that you've handed up, some of it is base numbers and some of it is not.
Now, I've been thinking, which is always an interesting thing. A certain streamer travels to somewhere to park his ass on a lawn saying, I protest. And people seem to send him a lot of money doing it. So here is a discount offer for only $200 a day. I will travel to a parking lot or a lawn, which is a public place, and protest against, and pretend to protest. Yes, this is snark. I'm actually not going to do it. But seriously, what the fuck? Yeah, let's keep going.
Some of it is clearly not search warrant affidavit stuff. I don't know what all this stuff is.
I'm sorry, Judge?
Some of this is search warrant, some of it's not. Some of it is underlying documents. I don't know what those underlying documents are. Maybe they're exhibits to an affidavit. I have no idea. They're not all Bates numbered. So I just want to make sure that there's no objection to this document. I know we just admitted it.
Yeah, by the way, Judge, that's the document from the state's discovery. So the reason why it looks like shit is not because of Miss Scapicchio. It's because of Adam Lally.
But there were representations about it, what it was.
I believe it was all in search warrant check.
All right, if we could hand this back to the ADA and do other.
All right, folks, this is important. From GD, my first and best moderator. Uncle Nick, you might be happy to know that your niece calls you Nick when she hears you. Oh, my heart melts. Folks, one thing I need you to always keep in mind, that what we are hearing is the corruption and everything is important on a society scale. But don't forget about the personal things. Things that makes you happy. This here makes me so happy. Oh, yeah. Oh, my little redhead niece. Oh, Nick. Oh. All right, back to the show.
Yeah, that's fine. The panel wants to introduce their copy, that's fine,
Hang on one second. We're going to see what we're going to introduce.
Oh, is it?
So should we,
Let's just replace it with yours, that's fine.
by agreement, we're going to replace Exhibit 2 with
Okay.
clean copy.
Well, Mark, this is Exhibit 2. Attorney Scapicchio, take that sticker off of the document that I just gave back.
So it seems like the state had a cleaned up version all this time. And now not until the judge says this is garbage. Oh, judge, we have a cleaned up version. Here you are. Oh, for fuck's sake.
Absolutely, Judge.
Thank you.
I'll take it. Thank you.
Okay, now,
Mr. Lally.
go ahead.
Thank you. Mr. Lally, you understood when you reviewed the materials that Trooper Proctor was sending you that they didn't contain the search warrants that you knew had been issued, right?
I'm sorry, when I reviewed the material?
Yeah, you said when you got the materials from Trooper Proctor, you would immediately review them, and that same day, you would put a notice of discovery together and give it to the defendant. That's what you said, right?
Yes.
Okay, so when you reviewed the materials that Trooper Proctor gave you from the state police, you had to have known that the search warrants weren't there, right?
I didn't.
You did?
Lally, you can't have it both ways. Well, we know that everywhere you turn, you are going to fuck people in the ass. But this is public. Don't you have shame? You in the 2025 hearing and in this hearing, you have explicitly said that you don't check the material that is sent to you. But now all of a sudden you have, but you still haven't. You checked the material, but you didn't realize that the warrants weren't there. That's not checking the material. That is staring at the front page at arm's length and said, yeah, good enough. Oh, dear.
I did not, Your Honor.
Did not, okay.
Had I realized, then I would have gotten copies of them and sent them to counsel.
Had you realized, well, you didn't read the damn thing at all. Derek asks, who ordered the warrants? Oh, we will get there. We will get there soon.
So did Trooper Proctor give you the search warrants and you just didn't turn them over? Or are you saying Trooper Proctor never turned them over to you?
No, as far as what I provided to you, as far as discovery was concerned related to search warrants, is what I had been provided by Trooper Proctor. I know that there was at least at one point a conversation in reference to there was not a partial affidavit, but an affidavit without an application return and copy of the warrant itself. And I never received it, therefore you didn't get it.
But you knew I was looking for it. Did you call Trooper Proctor and say, hey,
I did not.
Search warrants outstanding.
First
Can you get me those, please?
Objection to.
I would disagree with that. I did not know that you were looking for it. I don't think it ever once.
You didn't know the defense were looking for the warrants? Mr. Lally, warrants are automatically discoverable. It's not that you have a choice. It has to be handed the fuck over. So if you now claim that you didn't realize they weren't there, yeah, but when you were made aware, what, and you still did fuck all.
Came up as far as our conversations regarding discovery was the 2021 search warrants.
So are you saying that search warrants aren't Rule 14 discovery, sir?
I'm not saying that the onus is on you at all. I'm just saying when you say that you knew I was looking for it, I didn't, because we never talked about it once.
Well, we talked about getting all the exculpatory evidence from Mr. King, didn't we?
In general
Done on
terms?
a number of occasions,
Oh,
right?
hold on. One question at a time. Which one do you want?
We talked about getting the exculpatory evidence from Mr. King, right?
As far as you filed motions to that effect, yes.
But you don't have to wait for a defendant to file motions. You know you have an independent obligation to turn over information to a defendant under the Constitution, right?
Of course.
And under Rule 14, right?
Yes.
So you didn't need a motion to say we needed search warrants, but if you needed one, Exhibit 1 also asks for search warrants, doesn't it?
I don't know.
Well, did you read Exhibit 1 at all?
Right now? No, I didn't.
Did you read it when you got it?
Of course, yes.
And do you have a memory of whether or not we asked for all search warrants that were issued?
Do I remember now what's in the motion that you filed in December of 21? No, I don't.
Okay. Do you remember the motion asking for all documents, all turret tapes, all brick reports? Do you remember that?
Objection.
What's that objection?
He either remembers or he doesn't.
My point is, it's been marked as an exhibit.
Yeah,
She took
it's in
it away from
evidence.
him, she's quizzing him on it,
Yeah, but she still needs to know about his knowledge about prosecute. Just on, well, it's in evidence. Well, that doesn't matter. She needs him to say it as well. Not because if, well, it's in evidence. Well, why the fuck is he on the stand if not for the defense to find shit out?
You didn't realize that you had to turn over the search warrant until when, sir?
Until I was made aware of it after Ms. Hickman took over the case.
So sometime in 2025, you realized that you didn't turn over the search warrants?
Yes.
And at that point, does anyone go to you and say, why didn't you turn over the search warrants?
objection.
Sustained.
Did you have a conversation with ADA Hickman regarding the search warrants?
Objection.
Yes or no?
Yes.
And did you indicate to her any reason why you wouldn't have turned over these search warrants?
Objection.
Sustained.
Judge, can I be heard on this?
Yes.
So, in addition to the haphazard discovery practice from the district attorney's office with respect to this witness, I'm trying to establish that the office itself had no policies and no follow-up when discovery was disclosed late. The only way I can do that is to ask him about the conversations he had with ADA Hickman, who's also been a witness in this case, Judge, about what happened. Because I'm assuming, and maybe I'm wrong, but I'm assuming that they would have had some conversation saying, how'd you miss it?
Okay. The objection is still sustained.
Yeah. Okay, so the judge doesn't want them to go further into this, but now it's on the record. Again, good lawyering. She knows, okay, this is the playground. I'm going to make a record out of it.
So you remember having a conversation with ADA Hickman, is that right?
Yes.
Were you shown the search warrant?
I don't see the relevance of whether he was shown the search warrants in 2025. They were disclosed in 2025. The question is, what was his practice and why didn't he disclose them before?
Yeah, but you just, not a few minutes ago, you sustained an objection regarding a question leading that way. Oh.
Right? Okay, go ahead.
So, did you have a practice within the Norfolk County District Attorney's Office of ensuring that you turn over search warrants?
I have a practice?
Did you personally have a practice?
No, not a
Because
practice.
the Norfolk County District Attorney's Office had a practice of making sure that search warrants that were generated out of the district courts were contained in the file and turned over to defense attorneys.
I mean, that would be the expectation, yes. I don't think it was a formal policy or a practice, but any discoverable material needs to be turned over.
Did you ever go to the Quincy District Court, sir, where these search warrants were generated, to get copies of them prior to their disclosure in 2025?
No, I did not.
But you knew they were issued out of the Quincy District Court, right?
That I did.
And you knew that they weren't contained in anything that you had turned over because you looked at everything you turned over, right?
So that would be the failing, is that I didn't realize that it hadn't already been turned over.
Because you never checked the freaking... this is starting to be a little bit of banging a dead, not banging, hitting a dead horse, because they won't get a clear answer from Lally, even if it's abundantly clear to us that he never checks anything. He's just a glorified filing cabinet. That is just the middle station between the defense and the investigators. He never actually checks any material sent to him to see if it actually complies with the notice of discovery. And I'm glad that the new prosecutor on the case is actually handing shit over, showing that Lally is glorified filing cabinet, but also showing that Proctor actively made the decision to not file, to not send discovery over. And it also shows, in my opinion, that Proctor changed actively how he investigated. He, how do I put this? It shows that Austrian painter fan former Trooper Proctor used different standards depending on how he perceived what evidence could show guilt, conveniently ignoring policies, evidence, and allegedly editing videos. That is the corruption of former Trooper Proctor. What will show guilt and what will not. What will show guilt is what he will hand over to the prosecutors. The rest is either gone missing, edited, or in some extreme cases, well, I don't know if it's extreme cases, he might have done this before, in my opinion, planting evidence.
Okay. So are we then aware that there were another 4 search warrants that were issued in 2022?
Yes.
Did you have any participation in drafting the affidavits for those search warrants?
Drafting? No.
Who drafted the affidavits for those search warrants?
My memory would be Trooper Proctor.
Trooper Proctor drafted them?
I believe so, yeah.
When he finished drafting, does he send it to you and say, is this okay? Can we file it?
It might be forwarded to my attention for edits or things of that nature, but I wouldn't consider myself drafting it.
Okay. And can you just remind us, do you remember what date Myles King was arraigned?
In this court?
Yes.
Sometime in December of 2021.
Okay. And then you remember in January 2021, after the arraignment, seeking search warrants for information regarding Mr. King.
Regarding Mr. King? No, I don't believe so.
Relative to anything in this case?
Yes, I think it was more of a geofence that they were looking for.
And why were you looking for the geofence information in 2022 after Mr. King had been indicted?
To try to identify the person that was with Mr. King when he shot Mr. Simmons.
I'm sorry?
To try to identify the second party that was with Mr. King when he shot Mr. Simmons.
And did you bring your request for the search warrant to the Superior Court and ask for permission to file the search warrant after indictment?
I don't believe so, no.
Yeah, as it seems, if a person is already indicted, this should be in front of that court, not another court, in front of that very court who accepted the indictment. And it seems like Adam Lally doesn't care, Trooper Proctor doesn't care. Clear violation of rules and procedures.
Do you know whether or not you have an obligation to do that once a defendant is indicted and you want to file an additional search warrant to bring that to the attention of the Superior Court?
That is my practice, yes.
And do that in this case?
I didn't do anything in this case in reference to search warrants as far as bringing a search warrant.
Sorry?
I didn't bring any search warrants, so I don't recall where it was brought.
Are you saying that Trooper Proctor did this on his own and you were unaware of it?
I'm not saying unaware. I'm saying as far as there was no, I was not involved in applying for search warrants.
Okay, so...
But Mr. Lally, you are the one prosecuting the case. You are the one responsible for things are going by the book. And I did hear you say that you were made aware of them. Well, now it's your obligation to make Proctor aware of, yeah, did you file it at the right place? But you didn't, did you, Lally? Because you're a lazy motherfucker.
But you knew they were happening, right?
Yes.
And so my question to you is, did you know that do you believe you had any obligation to come before the Superior Court after Mr. King was arraigned to ask for permission to file additional search warrants?
Any obligation? No.
Did you come before any Superior Court and ask for permission to file additional search warrants in this case?
Did I? No.
Do you know if anyone from your office did?
I don't believe so, no.
Now, do you know whether or not after a defendant is indicted, whether it's still proper procedure to go to the district, if they're indicted in the Superior Court, to go to the district court to request additional search warrants? Is that proper procedure, sir?
It can be.
It can be.
Yes.
Okay. Do you believe there's any mechanism by which once the defendant is arraigned in Superior Court, if you wanted to issue any additional search warrants, that a defendant has an opportunity to be heard?
No.
So I'd move to introduce the search warrants numbered I think they start with 2-1, 2-2, 2-3, and 2-4. My copies are not date stamped. I don't know if the Congressman has a problem with them, but you can look at them. Okay, we need a copy of these. So can I bring this around?
Yes.
These are the 2022 search warrants. Can you take a look at them and verify that we're talking about the same thing, please?
Appear to be, yes.
Those are the 2022 search warrants?
I believe so, yeah.
Okay. And in the 2022 search warrants, we're looking at information, Google information, is that right?
I believe so, yes.
Is that all you're looking for is Google information, or were there additional things you were looking for?
Google is what I recall.
Okay. So, you asked for information from T-Mobile, Sprint, AT&T, and Verizon, is that right?
That's my understanding, yeah.
And those are all Google warrants relative to activities that took place on the day of the homicide, is that right?
Yes.
Has that been introduced the 2022 search warrant on the next exhibit?
Any objection?
No, Your Honor.
Exhibit 3.
Thank you.
Just want to make clear for the record, these are not geofence. I know I can bring this up on cross.
They are geofence. Okay.
They're not
They are not.
tower dumps.
Okay.
I was going to get there, Judge.
Okay.
So, Attorney Lally, when you just reviewed these, your understanding of them is that they were geofence warrants, is that right?
No, they were tower dumps.
What's the difference between a geofence and a tower dump?
So a tower dump is essentially looking for any phone numbers that were hitting off a specific tower within a general geographic vicinity of...
Yeah. Tower dump, as he tries to explain, is what phones connected to which tower. So they do a tower dump to see, this phone connected here. Geofencing is what phones are in the general vicinity, not necessarily connecting to the tower, as in making a call, sending a text, just general connecting to it. Because your phone, if you didn't know, always looks for the best signal, regardless if you're sending texts, if you're watching the tubes, if you are calling somebody, your phone will always try to connect to the best source. So that is the difference between tower dump and geofencing.
Of a location that you're looking for, whereas a geofence is more, how I would describe it. It's a wider net, I would say, as far as capturing what devices or what.
Well, doesn't the geofence ask Google to give them all of the people who might have been in a specific area at a specific time?
Correct.
And the tower dumps ask for the phones that are bouncing off towers at a certain time period. Is that right?
Correct.
And so, as a result of these 2022 search warrants that were issued, do you recall receiving any data?
Yes.
What did you receive?
As far as what was the data?
You remember, you had to look at the data and said, hey, this works, this doesn't work, we need to do something follow-up, right?
We received the data was turned over to you, and then I believe it was Trooper Keith that wrote a report in relation to it. Essentially wasn't helpful information.
That the tower dumps weren't helpful?
Correct.
So that would be exculpatory to Mr. King, right?
Yes, which is why you got it.
Okay. So when do you believe you turned over the 2022 search warrant?
Let's continue.
Or is that a certain time period? Is that right?
Correct.
And so, as a result of these 2022 search warrants that were issued, do you recall receiving any data?
Yes.
What did you receive?
As far as what was the data?
You remember, you had to look at the data and said, hey, this works, this doesn't work, we need to do something follow-up, right?
We received the data was turned over to you, and then I believe it was Trooper Keith that wrote a report in relation to it. Essentially wasn't helpful information.
That the tower dumps weren't helpful?
Correct.
So that would be exculpatory to Mr. King, right?
Yes, which is why you got it.
Okay. So when do you believe you turned over the 2022 search warrant?
Whenever I received them.
When did you receive them?
I could not tell you.
Yeah.
Okay.
Could not tell because I think I think he's making shit up. He never checked the data. Never did. He just passed it along.
Do you remember anything about the review of the data that was received from the search warrant? Did you yourself review it, or did you have an expert from the state police or the Milton Police review the data?
It was an expert from the state police that reviewed the data.
Okay, and that's the report that you were talking about?
Yes.
And you believe at some point you disclosed these search warrants to me right after you received them, is that right?
Yes.
And you would have received them right after they were issued, is that right?
I couldn't tell you
And if this is correct, they were issued in January of 2022, is that right?
if that's what it says.
Yes.
Yes, January 13th.
So you would have disclosed them shortly after January 13th of 2022, right?
I don't know when I disclosed them. I disclosed them,
When you got them, you reviewed them, and that same day, you put together a discovery notice and you sent it out to me, right?
that was my general practice, yes.
Did you not follow your general practice with the 2022 search warrants?
I may not have had a copy of them on January 13th, 2022.
So my question is, when did you get them? When did you get a copy?
I would have to look at the notice of discovery, but it would have been within a short time prior to me sending that to you.
Okay. And so if these were returned on January 18th and signed off by Trooper Proctor on January 21st, would you expect the discovery notice to include, the next discovery notice to include the 2022 search warrants?
If I had copies of them, yes, but I
How
couldn't.
long does it take for the police to give you search warrants when they execute them and get returned? Is there like a lag period there sometimes?
Is there a lag period? I don't know when I received them.
You don't know when you receive them?
No.
Would there be something in your file that tells you received search warrants on such and such a date?
Notation in the file? No.
Again, as I said early on the stream, if I did this in my in my area of law, if I did what Lally does, I would be fired. I would not work another day. But for him, no, because plausible deniability. He just don't care. He never has.
Okay. And then let me ask you something else. Do you recall, was it your practice when you were working on this case to base stamp any of the discovery material?
No.
And did the North County District Office have a practice of base stamping discovery material?
I would say some DAs do, some DAs don't.
But your practice was to not base stamp, is that right?
It wasn't an affirmative choice, but no, I didn't bait stamp discovery.
Okay. And did you ever have any trainings on how helpful base stamping discovery is within the Norfolk County District Attorney's Office?
No.
Okay. In your practice of not bait stamping discovery, are you relying solely on the discovery notices that you produced to me to determine what information you turned over?
No, I mean, it would be, the notice of discovery would be what information has been turned over, and then if there was obviously whatever information is in the file.
Yeah, Gigi. No, he does not date when he received things that is supposed to be sent over. So there is no way to know if the January 2022 search warrant, there's no way to know when he actually got it. The only thing that the defense has is the notice of discovery. Again, plausible deniability. Well, I sent it when I got it, and if you didn't get it, it was that because I didn't have it, and I don't care enough about anything to actually find things out.
So I guess I don't think I followed that. So my question to you is the way that you keep track of discovery in this case, the notices of discovery that you sent to me?
Yes.
And in addition to those notices, there wasn't, as far as you were understanding, any other discovery out there, right?
Correct.
Okay. Now, you remember an individual, give me the Turner stuff. You remember an individual by the name of Turner, right?
Yes.
And who was Mr. Turner in this case? What role did he play?
Mr. Turner was an individual who was identified on ring camera who was providing CPR to Mr. Simmons.
So he was there at the time that Mr. Simmons, well, he's one of the people that were there at.
Yeah, this is the one that apparently the state did not disclose to the defense for quite some time, because the state relies on one trooper who claims that in the victim's dying moments, he whispered a name. This guy here was there at the scene and performing life-saving measurements. And according to another filing from the defense, he didn't hear any of it. But it took the state. Well, I think they are going to go into it, but let's just listen to it. Let's just listen to the explanation as to why this witness wasn't disclosed to the defense for years.
The time that Mr. Simmons was receiving aid, is that right?
Yes.
And he was at the head of Mr. Simmons' body, is that right?
I don't know if he was at the head of the chest, but he was in, yes.
Okay. And was he a black or white individual?
Black, I believe.
Okay. And when's the first time you heard the name Turner in the course of this investigation? Do you recall?
At some point, it took a bit of time, I believe, to identify. He didn't stay on scene, so it took a bit of time for us to establish his identity from talking to people around the neighborhood, and then I was given a name and I summoned him to grand jury.
When you were talking to people around the neighborhood, were you showing them a photograph of Mr. Turner?
To be clear, I was not walking around and talking to people in the neighborhood. Investigators were, and I believe that's what they were doing, is showing a photograph.
Hey, Mr. Honor.
Yes.
Can you review this document and tell me whether or not you recognize it?
I recognize what it is, but I don't recognize it, and that I haven't seen it before.
You haven't seen that document before?
Nope.
And what do you recognize it to be, sir?
It appears to be a photograph of Mr. Turner from.
Yeah, sometimes the audio goes haywire from the court. I can't do anything about it.
The video.
And you didn't know that back on July 27th of 2021, that the police department had a photograph of Mr. Turner, who was the person who was at the victim's head at the time that the police and the ambulance showed up? Did you know that?
I knew that there was obviously video depicted.
So, Adam Lally, the lead prosecutor in this case, there's a ring camera video showing witnesses. They screenshotted parts of one of these ring camera videos in order to try to find one specific person who was there but later left the scene. And Adam Lally, who was the lead prosecutor in this case from end of 2021 to late 2024, early 2025, has never seen this, according to himself.
That, but I didn't know that there was a photograph and a posted notice in regard to it.
Sound
So
will
the police
become
never
better.
told
by
you
the way.
they were showing a photograph around the neighborhood of who they thought might have been Mr. Turner to see if anyone could identify him. Because he was at Mr. Simmons' head when the police came and the ambulance came.
Not that I recall, and this is the one report that I was referencing earlier, as far as the report that I didn't receive.
This is from the Milton Police Department?
Yes.
You guys have any conversations with anyone from the Milton Department regarding Mr. Turner?
As far as, yes, as I mentioned, they were able to identify him. We had an address. We summoned them to the grand jury.
Did you ever speak to a Sergeant Clifton Murphy regarding Mr. Turner?
Regarding Mr. Turner, not that I can recall, no.
Sorry?
No, I don't believe I talked to her about. I believe he would have been the one to.
Sorry for I can't do anything. This is court sound, not. I can't do anything about it.
Give me Mr. Turner's information so I could issue him the summons.
What about Milton Detective Mr. Similodoro?
Not that I can recall specifically in relation to Mr. Turner, no.
Okay. So, when did you become aware of this photograph? So first of all, let me introduce it. I have a copy of the report as well.
Any objection? No, Your Honor. All right. Let's see. Are we on number 4?
I'm going to. Yeah, and here they discover that audio is shit, so they have a short break, I believe. Skipping.
Either the Milton Police or the State Police were showing photographs of what they thought was Mr. Turner to individuals in the neighborhood.
In 2025.
When in 2025, sir?
I don't know.
They didn't show this image of a witness at the scene. They didn't even try to find. Until all of a sudden the defense says, hey, who's this? And then all of a sudden the investigators, yeah, let's try to find this guy. Almost 4 years later, then they start to try to find a guy that was on the scene, captured on Ring camera.
Did anyone ever report back to you that they had a photograph of Mr. Turner?
No.
And you understood how important Mr. Turner was, right, to the defense?
Potentially.
Okay, because Mr. Turner was there when this alleged statement, Mizzy Cass did it, was supposed to have been said, right?
No.
I'm sorry?
No.
I'm sorry. Was there an objection?
Yes.
No, overrule the objection.
What's the answer?
No, that's not my understanding.
What is your, well, you said you didn't know anything about the photograph of Mr. Turner, so now you know he wasn't there?
No. You asked me whether or not I knew that Mr. Turner was there when the statement was made. I don't know that. When the statement was made, it was made to Officer Colligan, who was leaning into Mr. Simmons as he lay on the ground. I don't know that Mr. Turner was there because Mr. Turner was gone prior to the officers arriving there. That's why they didn't identify him initially.
Well,
So my assumption would be that Mr. Turner wasn't.
Stop. The officers described Mr. Turner, right?
No, I think they
The officers
described
described Mr. Turner. They described him as a heavy-set black man, right?
that they observed in the video. Yes, I don't think they observed him on scene.
Well, you never asked them, hey, do you know if Turner heard that statement? This was Mizzy Cash?
Did I ask them whether or not they knew that Mr. Turner had overheard or not? No, I
Did
didn't.
you ever send them out to say, hey, go find Mr. Turner and see whether or not he overheard the statement attributed to the victim saying that Mizzy Cash killed him?
That's why we were looking for Mr. Turner.
Okay.
In
So
2025.
the photograph that you became aware of in 2025, when was it generated? Do you know?
I don't.
Did you, so somebody else did this without your knowledge? Is that what happened?
Not without my knowledge. As far as my knowledge was,
You answered, you had no knowledge. And now all of a sudden, oh, I did have knowledge. This is why I believe Adam Lally is making shit up on the stand because he never cared enough about this case to keep himself informed. So now he is on the stand, desperately making shit up by being this insanely vague. Because that's what he does and has been doing for the past 21 years as an assistant district attorney. Not giving a shit.
That there were two individuals on the ring camera. One, we knew who it was, and the other person, I wanted to know who it was so that we could bring them into grand jury and find out what they knew, whether or not they had witnessed the shooting itself, overheard the statements, had any information inculpatory or exculpatory to provide.
Okay. And when you found out in 2025 that there was this photo being generated, did you have any conversations with anyone in the Norfolk County District Attorney's Office about that photo?
Yes.
Who'd you have a conversation with?
Probably be Ms. Hickman.
Attorney Hickman?
Yes.
Okay. And did you ever get to the bottom of why you weren't provided with a photograph of an individual who may have been an eyewitness to this crime?
No.
Overruled.
I'm sorry, what was the answer?
No, was the answer.
I didn't hear it, Judge, that's why I asked.
Okay, no problem.
Now, you understand that before the information was disclosed to me in 2025, Mr. Turner passed away, right?
That's my understanding, yes.
So the Secretary never had an opportunity to find him and interview him.
Objection.
We didn't.
There was an objection.
Okay.
Well, I mean, let me just understand. Having read the papers, my understanding was that Turner was brought to the grand jury
I'm getting there, Judge.
and invoked,
Yes.
right? So I assume that the grand jury minutes were disclosed. So the predicate for your question is, you know, maybe it's several steps away. Maybe the grand jury minutes involving Mr. Turner were never disclosed to you. I don't know, but let's get there.
Okay. So,
For the love of fuck, Judge, she's pinning Adam Lally to specific answers. She is trying to get him to stick to a certain story. Stop being in the way.
was Mr. Turner ever summoned to the grand jury?
He was.
And how'd you find him?
Again, I was given the information from Lieutenant Collins as far as his name, address, and sent him a summons.
Where'd you summon him? Do you remember?
I don't.
Okay. When he got to the grand jury, sir, did he testify in front of the grand jury?
He did not.
Why not?
He had indicated prior to the day of his testimony that he wished to speak to an attorney in regard to a fifth. We arranged for that as far as the duty attorney of the day to speak with Mr. Turner. That was obviously done outside of my presence. Then the practice would be if the attorney believes that there is a Fifth Amendment privilege to bring him over to this courthouse in front of a judge where he can assert that privilege on the record.
And did that happen with Mr. Turner? Did Mr. Turner get brought before a judge to assert a privilege?
Yes, I believe it was an in-camera hearing before Judge Cosgrove over in 25. I wasn't obviously present for.
Listen to that again. Remember that name?
Attorney believes that there is a Fifth Amendment privilege to bring him over to this courthouse in front of a judge where he can assert that privilege on the record.
And did that happen with Mr. Turner? Did Mr. Turner get brought before a judge to assert a privilege?
Yes, I believe it was an in-camera hearing before Judge Cosgrove.
Judge Cosgrove. So, Judge Cosgrove is the same Cosgrove, I believe, that is special prosecutor at the moment for the Commonwealth. Yeah.
over in 25. I wasn't obviously present for whatever the fifth was, but I was informed that he had a valid fifth and he was asserting it.
And the information regarding
Yeah, that's interesting. This person who was at the scene of this crime had a valid Fifth Amendment right of not self-incriminate regarding this very case. Now, I don't know that valid reason, but you can draw the conclusion that in some way, shape, or form, he was involved in this case in a way that may have him criminally responsible. That's more than a witness, more than your average witness.
Mr. Turner taking the fifth, when was that turned over to Mr. King?
I don't think it was.
You don't think it was?
No.
So an ex parte meeting with Judge Cosgrove resulted in a valid Fifth Amendment disclosure, and it was never handed over to the defense. Now, you know from my coverage of the Young Thug Rico trial, folks, ex parte meetings, hearings are the baseline of it. It is legally wrong. It's to not have the defendant there is just a violation of rights, and the only way for that to be saved, so to speak, is for either the court or the state to immediately disclose this to the defense so they can make something of it. And none of them, not Judge Cosgrove, nowadays Special Prosecutor Cosgrove, or the state, disclose it to the defense.
Why not?
I don't have a good explanation for that other than it was never asked for, and it's not really a state.
It was never. It was ex parte, fucker, an ex parte in-camera meeting in the grand jury. They can't ask for something they don't know happened. That is why this is always an ex parte in-camera meeting must always be disclosed to the defense. It's insanity. Absolute insanity.
Statement by him. I don't know that it's discoverable under Rule 14.
You don't know who could potentially be an eyewitness to the crime, shows up at the grand jury and takes the fifth. You don't know if that's discoverable to the defendant? Is that what you just said?
No, as far as the statement, there's no statement that I'm. There's nothing as far as what Mr. Turner said that I'm privy to.
You still have to disclose that it wasn't. Oh, for fuck's sake! Oh.
But the fact that he's taking the fifth, that he thinks he has an issue of self-incrimination, do you not believe that would have been exculpatory to Mr. King?
I think it's something that should have been turned over, yes.
So why didn't you turn it over?
I don't have an explanation for that.
Because you don't care.
All right. With respect to...
Was anything relating to Mr. Turner's identity turned over to the defense? prior to 2025?
Upon my subsequent review, no. Did I believe that it had been prior to 2025? That was my belief, but that was a mistake.
Yeah. Prior to 2025, the defense was never aware about the identity of this either eyewitness or somebody involved in the crime. For almost 4 years, that was never disclosed to the defense. It was never disclosed to the defense that he pled the fifth in the criminal case. That in itself, just that fact, an ex parte meeting in camera with the state, the witness, and the judge, where he pleads the fifth and gives the reason to pleading the fifth, a valid reason, that not being disclosed to the defense, that should be just, yeah, fuck off. Case dismissed. Why is Turner pleading the fifth? I have no idea. I have no idea. Neither does the defense. But the fact that they were not aware of his identity, not aware of this ex parte in camera meeting, was actively hindering them from investigating this avenue. This should be almost automatically, on this one issue alone, in my opinion, the motion to dismiss should be granted.
Mistaken belief.
And what is it that you believed was turned over with respect to Mr. Turner?
I thought that he was referenced not only, well, he's, as far as the video that he's depicted in was turned over, but as far as his identity, I was under the impression it was contained within the Milton reports that have been provided to counsel.
Okay.
And you found out it wasn't contained within the Milton reports that you provided me, is that right?
That's right.
That it wasn't disclosed to me till Attorney Hickman got involved in the case in 2025, is that right?
Objection.
I think it's already determined that it wasn't turned over until 2025, at least according to this witness.
Okay. Photograph of Mr. Turner. Do you know if it was generated from brick? The brick, do you know what the brick is?
I know what the brick is, yes.
What's the brick? Tell us what.
It's a intelligence gathering database of the Boston Police Department.
Is it the gang database of the Boston Police Department?
I don't think it's exclusively a gang database, but it is used to identify gang members, yes.
Okay. And do you see reference to the brick on the photograph that we believe is Mr. Turner on the bottom right-hand corner?
And there's reference to the brick? I don't know.
Yeah, I see. Do you see that word on that photo?
I see the word, but I don't know that this was generated. It was distributed by the brick, but I don't know that it was generated by the brick.
Okay. Did you have any idea when you represented the Commonwealth in 2025 that there was some reference to brick in Mr. Turner in a photograph that was possessed by the Milton Police Department but not turned over to me?
No. Had I been, you would have had it.
Okay. Was the brick a part of this investigation?
Lucky for us, or well, depending on how you look at it, every answer he says throws an investigator under the bus. His attempt to save himself by playing ignorance, weaponized incompetence, goes back to, well, the cops didn't hand it over, so I didn't know. Which goes back to how Trooper Proctor conducted this investigation. And Trooper Proctor is no longer protected by the police union or the DA's office. He's only protected by people who share his mindset. Other Nazis. The only way to support Trooper Proctor, in my opinion, is that the supporters themselves share his worldview. They are Nazis themselves. And it's quite tell. I mean, you can actually look up who the supporters of Trooper Proctor is. Because a bunch of them wrote a letter to the governor demanding that Michael Proctor get his job back. Conveniently and not surprisingly, they are also supporting Greg Connor for district attorney. So it's very, very easy to look up, in my opinion, who the local Nazis are in Norfolk County.
No.
So how did the brick end up on this flyer saying, if you have any information, please be advised, contact Trooper Proctor, Milton Police Detective Similidoro, or the brick? How did that end up there?
I don't know.
Do you know whether or not Mr. Turner has any brick entries?
I don't.
Do you remember who Mr. Turner's attorney was?
No.
Were you told at all what the substance of the Fifth Amendment privilege was of Mr. Turner?
No.
But you believe that a judge in the Superior Court found a valid Fifth Amendment privilege that disqualified him as having to respond to the grand jury subpoena, is that right?
Correct.
Now, you remember there being some, what's the camera? Ring camera? Ring camera video in this case, do you remember that?
Yes.
And do you remember the ring camera video with the two kids, one in a red sweatsuit, one in a green sweatsuit, that were seen, according to the witnesses, in the 911 somewhere near the crime scene? Do you remember that?
Objection.
Overruled.
I don't recall that in reference to a ring video.
Okay. Do you remember anyone putting in some ring camera at the grand jury? Was that you?
Yes.
And do you remember the ring camera showing kids walking down the street? One in a green sweatshirt, one in a green sweatsuit, one in a red sweatsuit.
No.
Nick, do you have that?
Lally doesn't remember. I mean, this is the crucial evidence in this case. And he doesn't remember who's on it?
Do you remember at all whether or not it was represented to you that what you were introducing at the grand jury with respect to this ring camera was the entirety of the ring camera? Is that what you understood when you were introducing it to the grand jury?
Yes.
Did you ever learn that it actually wasn't the entirety of the ring camera, that there were other things on the ring camera that weren't turned over, either to you or to me?
Objection to form of the question. I'm just trying to understand what.
It's compound, and I'll ask you to just break it down.
Sure. The ring camera that you introduced at the grand jury in the case against Mr. King, did you understand that to be the full ring video that police officers generated or seized as a result of this case, right?
Yes.
No one told you they edited it in any way, right?
No.
And if it was edited, you would have introduced the whole thing, right?
Correct.
Okay. And did you ever learn in the course of your...
Now, I have to say here, Ms. Scapicchio is slightly misrepresenting what actually went on with the ring camera videos. They will go through this later. Now, I understand, but it is slight misrepresentation.
Representing the Commonwealth in this case, that what you introduced in front of the grand jury wasn't the entire Ring camera.
Did I ever learn that? No.
Are you just finding out about this for the first time today?
Right now.
Okay. If I told you that Ring camera had an individual dressed in a green sweatsuit and an individual dressed in a red sweatsuit walking in the area of the crime at the time, would that have been something you'd sent your officers out to investigate?
Yes.
And did you do that in this case, sir?
Did I send them out to investigate something I wasn't aware of? No.
Can you think of any reason why a police officer would edit a Ring camera before sending it to the grand jury?
Technically, it's not edited, but I understand the question.
Objection.
Overruled.
Can I think of a reason? Sure. I mean, length, things of that nature. But if there's a video that's going to be introduced as an exhibit before the grand jury, I might, if I'm presenting the case, I'm going to introduce the entirety of the video. I might also introduce as a separate exhibit a smaller snippet or portion of it, but the entire video would be admitted as an exhibit.
And that was your practice back when you indicted Mr. King, right?
It's always been my practice.
So you introduce the entire video, and then if you wanted grand jurors to focus on a certain portion of the video, you do a clip and you introduce that as a separate exhibit, right?
Correct.
In this case, you introduced a Ring video that was given to you by who? Who gave you the Ring video? Do you remember?
Specifically, no, but my assumption would be Trooper Proctor.
Okay. And did anyone ever ask you to look at that Ring camera video that you introduced at the grand jury and look at the full Ring camera video before you testified here today?
No, up until right now, I thought that the video was the full video.
Can I just ask, the Ring camera video that we're referring to, where was it shot from and what area did it depict?
The one that, if I'm correct in what Ms. Scapicchio was talking about, would be depicting sort of the front area of Mr. Simmons' home where he was found, where he was being treated by Mr. Carter and Mr. Turner, if I'm correct in what she's referring to.
Okay. And that's where first responders responded?
Yes.
Okay. And did that Ring camera video, as it was provided to you, depict Mr. Turner?
Yes.
And did it also depict the first responders arriving?
Yes.
And did it depict that Mr. Turner was on scene when the first responders were arriving?
He's not visible on camera when the first responders arrived.
Okay. Go ahead.
Thank you.
May I clean something up here, Your Honor? I know I can do this on
I can't hear him. I'm sorry, what?
Could I just clean something up here?
Just have a conversation with Attorney Scapicchio.
Explain to him. Let's go, buddy.
Okay. I'll have to put it in.
May I explain it to the court? So, just to explain this out, grand jury exhibit number 21 was a 2-minute and 1-second clip. It was provided in Notice of Discovery 1, number 46. The time on the clip is 18:08:31 Eastern Standard Time. The second video that the witness is not aware of, and I have in my hand, and I'd be happy to mark it as, or counsel can mark as an exhibit, is a Ring video provided on May 15th of 2025. It is 10 seconds in length from the same residence, and the time on the video is 16:59:47 Eastern Standard Time.
Yeah. So when Rosemary Scapicchio asked about the entirety of the Ring camera, she's referring to 2 separate videos. In her questioning, she made slight misrepresentation about, you could interpret it as it is those 2 are connected. They aren't. It's an hour apart. But it's still close enough in time to an actual crime that it should have been disclosed to the defense and then brought up in motions in limines, motions of whatever's before the court. But since The state hid it. Now it's an issue. Sadly, the state weaponizes against Scapicchio. This slight misrepresentation. Even though they have Lally on the stand lying his ass off, sadly, this is the rules they have to play by in this court, in this county. That the state will get away with almost everything. The defense doesn't.
This is noted in Discovery 31, date stamp 002026. And just so your Honor is aware of the timing on this, the first 911 call came in.
That's notice of discovery. What did you say? 30 something?
31.
31, and it was what?
Date stamp 2026.
Okay.
So the second product, this ring thumb drive, is 1 hour prior to the homicide.
The 10-second clip?
So this is the full video, Judge.
That's the full, I thought you said it was 10 seconds.
It's a 10-second clip that was provided on May 15th, 2025.
Yeah. What might be not as clear here is that this was not the cops going there to download the entirety of the Ring camera. This is what was provided to them. Again, we have no idea what was actually, if there's more on that Ring camera. Because just as in the Karen Reed case, they didn't care. They had their suspect. Why would they collect something that might speak against it?
By A.D. Hickman.
Your Honor, let me clarify. I produced it. It has on it is the grand jury exhibit, which is a 2-minute and 10-second one, as well as the 10-second clip that I produced as well. So both clips are on it.
Excellent.
May I introduce the judge?
I thought you were referring to a Ring camera video that was the original source, if you will, of the 2-minute and 1.
Yeah, and now the judge has issues. We've been listening to this for 2 hours, and now the judge has issues with something represented.
Second clip, which is grand jury exhibit 21. I'm sorry?
It's the same exact house.
Your Honor, it's not an hour. It's a 10-second clip about over 1 hour prior to the homicide.
I understand that those are the two clips you're talking about,
Yes.
but I understood Attorney Scapiccio's questioning to be suggesting that the 2-minute and 1-second clip was a subset of a much longer Ring camera video that was obtained by the police at the time that they collected Ring camera from
I
that
believe it was,
location.
Judge.
Okay.
I believe that this video is prior to and the day of or the hour of the.
Yeah, but it's 10 seconds. It's not a subset, or it's not a greater set out of which the 2-minute and 1-second clip was taken.
No, Judge, because it comes from the same exact home, the same exact Ring camera. What they introduced in front of the grand jury was this clip of what happened when Mr. Simmons was shot. What they had and didn't introduce, in my opinion, is what happened right before Mr. Simmons was shot. Who was in the area before Mr. Simmons was shot? It's important to us, Judge, because there was a description.
Before you start arguing your closing, okay?
I'm not trying to do my closing, Judge. I'm tell you why it's important.
I understand. They may have had a clip of 10 seconds before, an hour before this incident, an hour before the 2-minute clip that was introduced in front of the grand jury. That's a different animal. That's different than what you were suggesting in your questioning, which was that the 2-minute and 1-second clip was a subset of a much longer clip that encompassed the 2-minute and 1-second clip introduced to the grand jury.
And that's what I believe happened. They're saying it's two separate.
Do you have the longer clip that the 2-minute and 1-second clip was a subset of?
Well, I have the two clips, Judge. It's a continuation of the same view from the same camera.
But
So
is
what
there
got
any
introduced
is there any evidence that the police or anybody investigating this case had the whole Ring camera video from whatever time, 1659 through 1810?
There's an email, Judge, which purports to be from an individual who's trying to contact the district attorney's office about Ring camera. It was Mr. Proctor's job to collect the Ring camera. There is an email suggesting that this individual had 2 Ring cameras available for collection. I don't know what on earth Trooper Proctor would go and get 1 Ring camera and leave the other Ring camera and not look at it at all, Judge. I don't know. I plan on asking him that when he takes the witness stand.
Your Honor, if I could just clarify for the record, an email was accompanied with the second Ring video that was produced on the 2066, I believe is the date stamp. There's an email that was dated and it's date stamp 2016 about this separate 10-second clip that was also forwarded by the residents of that home to the Milton police. That is the...
Yeah, it was forwarded by the residents of that home. And it seems like this was forwarded years later. Doesn't that show that Ring cameras apparently can hold this a lot longer? So in the Karen Reed case, why didn't they go back? Well, for the same reason they didn't go back in this case. Why look for something that might show we have the wrong guy? This is the practice of Massachusetts State Police when they are investigating crimes. Don't look for things that might speak against guilt. Only look for things that speaks to guilt.
10-second clip that occurred 1 hour prior to the homicide. No video of one continuous has been inferred by Ms. Scapicchio that 2-minute, 10-second was somehow edited out from a 1 hour video. There was a 10-second clip that the homeowner in that email that was provided to defense counsel say, I found this too, that was provided from that same residence, and then the 2-minute and 10-second video that was from that residence that was put into the grand jury.
Yeah, so the resident of that home found 2 separate videos, and the investigator never went there to see, can we find something more? No.
There is no 1 hour video that anything has been edited out to. And the email where that 10-second clip came from was provided to Attorney Scapicchio explaining where that came from.
Is there a state police memo by Trooper Proctor that says, on such and such a day, I went to such and such a location, looked at their Ring camera video, the only relevant section was this 2-minute and 1-second clip, or describing when and how Trooper Proctor got the video?
Trooper Proctor, my understanding, is not the one who got the video on it.
Okay.
This came into the Milton Police Department. There is not a report. It was provided by the homeowner, the 2-minute and 10-second, and then the homeowner determined that there was a second clip that was approximately 1 hour prior to the homicide, which is what was produced when I took the case over, when I found that email.
But nobody actually went to the home to look at the video to see whether there was anything relevant on the Ring camera?
I don't believe so, Your Honor.
Nope. Now, in this case, at least that homeowner found stuff, forwarded it, because the investigators, they didn't care. Just as now, in the Karen Reed case, among the first reported things that got out into the news was that they had the event on Ring camera. And then, all of a sudden, they didn't. Now, the conclusion I draw from that is that they actually collected Ring camera expecting to find can read backing up and hitting Jan. Once they checked the ring camera, it did not show it. So they went from telling the reporters we have ring camera to not having it at all. And they never went back to collect any ring camera from that street. Because, folks, what you may not, what some of the antis conveniently forgets is any ring camera from that street that night should have been collected. Because if it actually happened the way the state says it happened, she would have been seen driving at the time that they claimed she drove, reversing at the time they said she was reversing at that street. Ring cameras may have or could have shown the exploded out taillight, but they never went to check because it never happened.
Okay.
So, Judge, yeah. My understanding, just so my position is clear, my understanding is the same homeowner sent 2 videos or disclosed that 2 videos existed.
What's your basis for that understanding?
Because there's an email that says, here's the 2 videos.
2 different video clips, relevant clips, or 2 different video angles from 2 different ring cameras?
The same ring camera, Judge.
One ring camera,
On the house.
okay.
So there's an email that suggests, Judge, that's dated July 11th of 2021, that suggests this is a ring camera, and that they were forwarding this to the Milton Police Department. Now, what gets introduced in front of the grand jury is one of those 2 ring cameras, and I believe it's represented that it's all of the ring cameras that they have, and then I find out sometime in 2026, it's not all of the ring cameras that they have, and that the second ring camera that got disclosed in 25 or 26, I'm losing track of all the late discovery here, but when it gets disclosed, Judge, I realize when I look at it that the video that is prior to the incident shows 2 individuals who were described on the 911 tape, one having a red sweatsuit, one having a green sweatsuit.
Yeah, that is the issue here. How are these 2 clips in our report connected? The same 2 individuals are on both clips. Same individuals. The descriptions on the 911 call and the ring camera an hour before seems to describe the same people. That is what makes these 2 connected. Who are these 2? Why were they there an hour before and immediately as the crime happened? And after, were still there, apparently, after the crime happened. Yeah, as Jan says, reported in the 911 call. That's the tie-in between these 2 clips. Because if these 2 individuals were walking around that area, they are at least witnesses as to who else was around there. And it was never disclosed until, as I believe Scapicchio said, until this year. Until this year, 5 years later.
They're walking by the house that has this video, and one of the individuals keeps looking back, as if he's looking back or looking for somebody, which becomes exculpatory to me to be able to look that up, Judge. And I'm just trying to figure out, if you got 2 videos, why'd you only introduce 1, and why didn't you tell me there were 2? That's all I'm trying to establish.
Okay, go ahead.
We marked the 2 videos.
Any objection to marking the 2 videos?
Not at all.
Okay, are they on a single thumb drive or 2 different thumb drives? Single thumb drive, okay, by agreement. Exhibit 5 will be the thumb drive.
Thank you. So, Attorney Lally, had you known that the homeowner had sent 2 videos to either the Milton police or the state police, whoever it was, would you have introduced both videos in front of the grand jury?
Yes.
And would you have turned both videos over to me in 2021?
Yes, of course.
Now, Oh, can I just have a minute, Your Honor?
Sure.
So the last thing I want to talk to you regarding the late discovery aspect of this is your 2025 grand jury testimony regarding Mr. King's jail calls. Do you remember that?
Grand jury testimony?
Well, let me put it this way. Sometime in 2025, after Mr. King was indicted, did you go in front of a separate grand jury asking them to return the jail calls of Mr. King because they've never been returned?
To make the return of the jail calls, yes.
But that wasn't the grand jury that indicted Mr. King, right?
Correct.
And you presented evidence to a separate grand jury, right?
Yes.
After his indictment, right?
Yes.
And you indicated to them that it was just a formality, right? That the grand jury never actually returned the jail call, so you couldn't introduce them at trial. You needed.
Yeah, he conveniently forgot that they apparently in Massachusetts, if it's not disclosed during the grand jury for them to take a part of, especially jail calls, you can't introduce them as evidence at trial. So he instead of telling the court, "Hey, fucked up. What can we do about it?" He just summoned a new grand jury, goading them into accepting it by saying it was just a formality.
A separate grand jury to return the information regarding the jail call. Is that right?
I don't think I put it that way. Essentially, so because the jail calls were subpoenaed pursuant to the power of the grand jury, anything like that has to be returned to the grand jury. That's how we obtained them. We obtained them back in 2021.
And I guess they didn't go before the grand jury in 2021. Is that what happened?
No.
They got returned to a police officer. Is that what happened?
I'm sorry, they got returned to a police officer?
Right. In other words, Trooper Proctor had them, right?
Trooper Proctor had the Norfolk ones. I had the Plymouth ones.
Okay. So the two sets of jail calls for Mr. King. There were Plymouth ones and Norfolk ones.
Correct.
Trooper Proctor had which one?
Norfolk.
And you had the Plymouth one?
Yes, because the Plymouth ones came in prior to us getting the Norfolk ones. I think we only got the Norfolk ones a week before the indictments were returned.
Okay. In any event, you go in front of a separate grand jury in 2025. What was your authority to go before a separate grand jury in 2025 to return jail calls that had been subpoenaed by a grand jury in 2021?
Again, so anything subpoenaed pursuant to the power of the grand jury has to be returned to the grand jury. It doesn't have to be the same grand jury that heard the case. Wasn't asking this grand jury to vote on anything. There was no presentation of any indictments or anything of that sort. It was just a process by which they have to be returned to a grand jury, whether it's jail calls, medical records, business records, anything that summons pursuant to the power of the grand jury has to be returned to the grand jury.
Did you notify the court that you were going in front of a separate grand jury to try to get these jail calls certified so you could use them at trial?
First of all, they were already certified, so I wasn't trying to get them certified, and I had no intention of using them at trial because there's nothing of any relevance on them.
And President Trump,
Yes.
is this your grand jury presentation on January 28th of 2025 regarding Mr. King's jail calls?
Yes, those are the minutes.
Okay, without objection, Exhibit 6.
No objection. I may move to impound those afterwards because they're grand jury minutes.
Doesn't matter if they're apologized. I don't know.
I move to impound.
Is
That
there,
particular exhibit.
there's no testimony, right?
It's just AJ Valley telling the grand jurors that he needs them to return these jail calls because he needs them to be able to introduce them at trial. That's all.
All right. What's the reason for impoundment?
I didn't have.
I'll file a motion. She can move on right now.
I'm sorry?
Council can move forward. I'll file a motion.
All right, Exhibit 6 will be admitted.
So, thank you, Your Honor. So do you know whether or not Trooper Proctor ever had access to Mr. King's jail calls from Plymouth County?
I don't.
I'm sorry?
I don't know if he did or he didn't.
Did you ever review in the course of the discovery, before you disclose them to me, Trooper Proctor's notes?
I'm sorry?
Trooper Proctor's notes, his handwritten notes. Did you ever?
Notes with regard to the Plymouth jail calls or something else?
These are the jail calls.
Okay.
This is interesting. I wonder, now when we know that Trooper Proctor is big fan of Austrian painter, what's actually in his notes?
What exactly was the question?
Did he know?
Did Proctor know? Did Lally?
Did Lally know? Did Lally know? Did he review this? That's exactly what I'm going to ask him. So can I approach?
Yes.
Your Honor, may we have a second? Council's reviewing it.
Sure.
PDA Hickman's reviewing it for a second before she asks a question. Thank you.
No. A little hard to read, but based on the penmanship, but no. I have no idea.
You don't know what it is?
I don't know what his handwriting looks like. It appears to be notes. I've never seen that before.
You've never seen the notes before?
No.
Again, something he should have collected. If there's note taking on this while Proctor is listening in on jail calls, that's evidence that should be handed over. And this is apparently the first time Lally has seen it.
So during the time period that you represented the Commonwealth, you didn't know that Trooper Proctor had notes of listening to jail calls from Mr. King before there was a return on those in front of a grand jury?
No, I didn't.
Okay. And with respect to the notes, do you see anywhere in these notes references to Mr. King's social media accounts with passwords?
I mean, I see the word password.
Does it appear to be connected to an account of Mr. King?
It could be.
You know what you sit here today, Attorney Lally, when it was that prosecution became aware of Mr. King's passwords and usernames for social media?
Do I know? No.
Do you know?
I'm sorry, I couldn't hear you.
Sure. Do you know, as you sit here today, when the Commonwealth became aware that somebody in the police department had access to the jail calls and was taking note of Mr. King's social media accounts, usernames, and passwords?
Objection. Just two questions there.
Fair enough. Can you break it down?
Sure. Do you know whether or not anyone from the Commonwealth understood that a police officer was listening to Mr. King's jail calls and being apprised of Mr. King's social media accounts? Do you know that?
I don't know anything about that, no.
And also being apprised of usernames and passwords to Mr. King, because he was talking about them on a recorded line in the jail, right?
And that's what you're saying? Do I know anything about that? No.
So did any officer ever tell you that they were listening to the jail calls of Mr. King before there was ever even a return on Mr. King's phone calls?
So there was a separate trooper, Gendron, who listened to the bulk of the Norfolk calls prior to the return of the grand jury.
And what about the Plymouth calls?
The Plymouth calls, I had listened to the entirety of those 170 calls.
I'm sorry?
I listened to the 170 calls from Plymouth.
And when you listened to the 170 calls, there wasn't any information that was inculpatory to Mr. King, is that right?
Inculpatory, exculpatory, really anything relevant.
Okay. And in terms of...
Isn't that in itself, I mean, if he is this talkative criminal and he keeps making phone calls and not once he is saying something, yeah.
Are you looking to introduce these notes? All right, we'll take them and mark them without objection, is that right? Okay, Exhibit 7 will be the notes.
I might need somebody else's copy because mine has highlights on them. I don't want to introduce the highlights. This is basically at 429. Now,
Attorney Scapicchio, how much more do you have?
I was just getting into, and I was going to ask the court for permission to get into some of the text, emails, and voicemails of Trooper Proctor with this witness, Judge.
Okay, so that's the last of what you've got?
That's the last section of what I have.
All right, so why don't we take our breaks now? We'll come back at 20 after 11 and reconvene, okay?
Thank you.
And through the power of recapping, we're back.
We're back. Matter of the Commonwealth versus King.
Yeah, not a single phone call Mr. King made in his time in jail has he incriminated himself.
Okay,
Not
Mr. Lally, I'll
single
just
one.
remind you, you're still under oath, okay? Yes.
Hey, Your Honor.
You may.
I was going over my notes at the break, Judge. There is one more additional
Go ahead.
exhibit that I want to introduce before we move on to the Proctor materials. And that is, I think I provided the court this morning a hard copy of the transcript of the individual hearings in this case that we had transcribed. I've provided a copy of this to the district attorney's office, and I just want to move to introduce them to the court.
You want to introduce all the various prior transcripts of hearings?
Yes.
It's about 3 inches of paper. I left it all in my office. Maybe it's 2 inches of paper. I don't know.
It's also an electronic copy. The court has to give a paper copy if we have something.
Yeah, great.
I can provide another paper copy.
No. I have it in my office. I mean, it's not like I've highlighted them. They're sitting there. They should be on the round table in my office, Tim. Thank you. It's, they're all transcripts.
I have a few questions about those transcripts, Judge, and then I'll move on to the
Okay,
Proctor.
we'll see if we can get them in. Why don't you go on and we can come back to this.
So, Attorney Lally, we had a number of discovery conferences in this case, is that right?
A few, yes.
Okay. And do you remember at various times during discovery representing to the court that discovery was either complete or almost complete?
I don't believe I represented it was complete, but almost complete would be accurate at different times, yeah.
Okay. And when
It's still not complete. And Adam Lally to the court has said from more or less the first hearing, discovery is complete or almost complete.
when you said discovery was almost complete back in 2020, I think it was 2, was that based on your understanding that you had everything that the Milton police had and everything that the state police had because you were relying on them to give it to you?
Objection.
You think we've covered it, but I'll give you a little leeway.
Thank you. Is that why you were representing to the court that discovery was complete or almost complete?
If I was representing it to the court, then that was based on my understanding. Yes, is that I'd asked for.
And you made those representations based on your understanding that you asked for everything and you assumed you got everything. Is that right?
These questions assume that he remembers what happened at something in 2022 that Your Honor has right in front of you.
Yeah.
I think there's a.
And it's over, and it's lots of different hearings. So lots of different statements.
If she,
It's a generalization question. I appreciate.
Well, isn't this what you ask witnesses at trial? Do you recall this date? And somehow cops have immaculate memory of certain dates and certain events, while ordinary witnesses, private citizens, they might not recollect. So why are we treating Lally as if he's a moron, like he's a commoner or something of the sort? Why? It's his fucking case. He lived with it for 4 years. He should have at least a vague recollection of when and where. Stop protecting crooked people.
Appreciate the problems with that.
So don't answer the question, Judge, please.
The question.
Mindset, Judge. I think it's state of mind. It's important to understand the discovery disclosure delays in this case, Judge.
Right, but we've covered that. That is to say that, he passed things on when he got it. He was relying on others to review the files in Milton and the state police. And if he noticed something was missing, he would ask them. But, basically he was relying on them to give him everything that they had. So I get that picture.
Fine, Your Honor, I'll move on. So the next set of questions, Judge, has to do with the Proctor audios, the Proctor text, and the Proctor photos and emails. I just want to alert the court, and I'm sure you already know, that some of this information is pretty offensive to the Black and brown community. I would never use the words that Trooper Proctor used, but in the initial videos that we want, the audios that we want to play, Judge, the word they used, and we couldn't find a way to redact them out.
I have the material in your papers, right?
The audios I don't believe you have, Judge.
Are you looking to introduce them?
Yes.
Is there any indication that this would?
Yeah. Now, if you didn't know, Proctor, Goods, and other people's racist, misogynistic, Nazi commentary about to friends, family, and colleagues was not only in text form. It's on voicemails. It's on audio.
Has ever heard them in the context of his work on this?
Yeah. Oh, because tone matters as well as when you're saying it, how you're saying it, and what is actually said.
Case?
That's the whole point, Judge.
He never did. So you can ask him.
Judge, the point is, the Commonwealth has made the claim in their opposition to the motion to dismiss that Trooper Proctor's opinions about Black and brown people would not have affected his ability to properly investigate this case. And to the extent that that's the Commonwealth's argument, I want to ask this witness, who had the case for years.
I don't think that's their argument. I think their argument is it shouldn't justify dismissal of the indictment. Their argument is, but
Judge, let them argue that point, not you.
But leaving aside that argument, this witness can only provide very limited evidence, if any, relevant to this particular question. So if you have a foundational question you want to ask him, did you ever hear Trooper Proctor's personal cell phone, messages or WhatsApp messages? Did you ever read them or did you ever ask for them? You can ask that.
The point being, Judge, that the idea that Trooper Proctor left his bias at the courthouse door when he conducted this investigation is something that I have to probe in order to produce enough evidence to suggest that that's not possible. And this is the witness who was involved in the case on behalf of the Commonwealth for years. And I think I have a right to ask him whether or not these statements and videos, had he known about them, whether he did or didn't. Let's assume he didn't.
Well, let's assume the predicate let's not assume the conclusion. Okay, ask him the question. Did he know about it? And then we'll confront the next question. What would you have done if, the hypothetical?
Right.
Okay, but go ahead. Why don't you ask him whether he had any knowledge whatsoever about any of this stuff when
And now Lally knows how to answer.
he was representing the Commonwealth in connection with the King matter.
Thank you. Attorney Lally, how long did you know Trooper Proctor before you were assigned to the King case?
Whenever I didn't know him prior to his assignment to the State Police Detective Unit. When he became assigned to that unit, I couldn't say.
Had you worked with him before the King case?
Not on a case, no.
Would you work with him on something that wasn't a case?
No, what I'm saying is there could have been a situation where I spoke with him in regard to a call from the organ bank or some issue with the medical examiner's office or some unattended death that wasn't a case or something like that. But as far as working with him on a case, I believe Mr. King's case would be the first.
Okay. And how often would you say you had interaction with former Trooper Proctor?
In relation to this case?
Yes.
As in relation to this case would be whatever days there were for grand jury, court dates if he was needed, but, might talk to him before or after a court date in regard to whatever was discussed as far as discovery, things of that nature, but that's pretty much it.
Were you aware of any of the biases in racist beliefs held by Trooper Proctor when he was investigating the King case?
No, that was never communicated to me or in front of me or anywhere near me.
And had you been aware of Trooper Proctor's biases and racism, would you allow him to continue to work on Mr. King's case?
So I think that assumes that that's my decision. What I would have done is alerted both my supervisors, his supervisors, and made a strong recommendation that he not continue.
You would continue to work with Trooper Proctor after he called black and brown people animals?
That is absolutely not what I just said.
Okay.
What I said is I don't determine who the state police assigns as a case officer to a case. What I would do, based on the abhorrent nature of those communications as I understand them, would be to alert both my supervisors within the DA's office, his supervisors within the state police, and strongly recommend that he not have anything to do with the King case or any other case.
Why is that?
Based on the nature of my understanding of what's contained, I haven't seen or heard them personally, but it's utterly unacceptable.
Do you believe that Trooper Proctor's opinions of black and brown people dehumanize them?
I don't see how you could see it any other way.
Overruled. That can stand.
You don't see how you could see it any other way?
Correct.
Would you agree that Trooper Proctor's opinions and racism is an expression of hostility towards the black and brown community?
Objection.
I'm not sure how his opinion matters. He's already said that what he would do if he was alerted to.
For the love of fuck. You stop with this shit, Judge. This is Rosemary Scapicchio pinning down Lally to a story and pinning him to opinions. Because this here shows that even the prosecutors, if they have known, if they have had the power, would have thrown him the fuck off any case. Yeah, this is quite important because this is something they can use in their defense. Because, folks, the lead detective in the Myles case, up until he was yeeted out of the police force, was Trooper Proctor. Everything went through his hands. And if the then DA, the assistant DA in charge of the prosecution says, I will not accept him as a lead detective, that means even the DA's office believes we can't use what Proctor is producing.
To it, and he had not been alerted to it.
So you're saying I can't have the question, Judge?
Correct. So I sustain the objection.
Just note my objection, Judge.
Okay.
So, are you aware, Attorney Lally, of the depth of the hatred that Trooper Proctor had for Black and brown people?
Objection.
Is he currently aware?
Yes.
I don't understand the relevance of his current knowledge. So this objection is sustained.
If I might, Your Honor,
Sure.
I think a preliminary, you asked for foundational questions. I would ask perhaps when and what he is aware of.
Sure, it assumes a lot.
About the mindset of Trooper Proctor.
Sure.
So have you heard any of Trooper Proctor's voicemails that he left with his group of friends about the Black and brown community?
No.
I'd like to play one of those voicemails.
He's never heard them.
Right.
So the objection sustained.
So, Judge, with respect to this witness, the Commonwealth is making a claim that, and it's my understanding of the claim, maybe you see it differently, the Commonwealth claim is that to the extent that Trooper Proctor's racism existed, that it didn't, my understanding of the argument is that it didn't impact his work information because it was only on his personal cell phone. I want to talk to this witness because I don't expect Trooper Proctor to ever take the witness stand, Judge, and we all know he probably won't, about those texts, Judge, so that they become part of the record and that there's an understanding of how vile and disgusting Trooper Proctor's texts are as it relates to the Black and brown community. And I have to set it up this way, Judge, because I expect to call an expert who has reviewed the text, who has listened to the audio and the video and looked at the photographs and would be able to render an opinion about whether or not any person would be capable with this type of explicit bias of doing an impartial investigation.
Okay.
Your Honor, the Commonwealth had indicated in its opposition to the second supplemental motion that it would stipulate to the
Can you
admissibility.
speak right into the microphone because I'm having difficulty hearing you, and so is Attorney Scapicchio.
Yes, Your Honor. Your Honor, the Commonwealth would stipulate to the admissibility of the productions of materials from Mr. Proctor's phone that were provided to defense counsel. I know defense had filed a copy of the thumb drive with the court, I believe, when the motion was filed, and the Commonwealth previously indicated it seems that this is important material for the court to look at, and rather than going through a chain of custody witnesses, I would suggest the parties could stipulate that the court could have that thumb drive with the two productions of materials the counsel was referring to review.
Okay.
That's fine, Judge. Are you saying that I can't go through them with this witness or any other witness?
Well, if they've seen them and if they had a choice about whether they were going to be turned over or something like that, if they knew about them in advance, that's one thing. But to ask somebody their opinion about text messages that they never had privy to when they were working on the case, in all due respect to Mr. Lally, I can look at them, and I'm not sure what his opinion now about them is going to add. And so he's not being offered as an expert on the effect of racist communications on somebody's work product. And so I think you've gotten from him everything that you can get from him.
Yeah, and I can't do anything about the audio. The audio from the court sometimes goes haywire. Now, here I do agree with the judge. I understand how and why Ms. Scapicchio wants to pin his opinion down on things. But she already got some of it in. Now it's getting to be a bit of a stretch with him. Now, what she can do is find some other person within the Massachusetts State Police who was also involved in this case. Like, let's say Buchanan. Sergeant Good might be involved in some way or form. There should be plenty of witnesses who has decades-long experience in listening to Proctor being a Nazi.
There are.
You have the thumb drive? We can admit it.
I don't have the actual thumb drive yet. The thumb drive is actually part of the record here. What I'm trying to do is point you in a certain direction of photos, emails, and texts that I expect my expert is going to talk about. I don't know if you want me to wait until my expert takes the stand, or whether or not you want me to introduce them now, Judge.
No, you don't have to introduce them now. You don't ever have to introduce them. It's totally up to you. But I don't think this is a witness to question about them.
All right, so
if you have any, do you have any other questions for this witness relating to the transcripts?
No, Judge, let me ask my office.
Here are the transcripts that you were asking about that we've gotten back from my office.
Yeah.
You want to introduce those?
You want to introduce?
That is a hefty bunch of paperwork. And folks, what he holds there is only the transcripts and text messages that is related to this case. There's more. There's so much more.
Yeah.
As one package or individually?
One package.
One package. Any objection?
That precede the beginning of 21 transcripts by my count.
Yes, sir. I think the last one is day one of the motion to suppress hearing. Motion to dismiss hearing. And I would ask for permission to get funds to transcribe this hearing as well, Judge. But if the court's ruling is that I cannot go through any of the Proctor materials with Attorney Lally, I don't have any additional questions.
Okay, cross-examination?
No, my objection.
Yeah, we will not go through the cross-examinations. It's really not necessary. Folks, Adam Lally is a glorified filing cabinet. He never checked what he got from the investigators. He never did. He never checked the actual evidence. He never checked if what the defense asked for actually was in the material. He never checked if what the material he got was according to Rule 14, the automatic discovery. He never did for years. And that is why Myles King is still in jail 5 years later. This hasn't gone to trial yet, as of 5 fucking years later. Because the state troopers, Trooper Proctor and the rest of every cop in that has to deal with Norfolk County knows that they don't check. So they just, let's ignore sending that piece over. Let's ignore sending that piece over, because if we do, the defense might cause trouble and ask for material they are entitled to. And it's absolutely vile. This is not how justice is done to anyone. Anyone. Now, there will be a new hearing. I believe it's in September. Now, in September, I will be in Indiana. And so depending on the date, I might not be able to cover that. Yes, I'm traveling to Indiana. I will be landing September 10th and leaving again September 24th. I will be visiting Delphi, Indiana for the Delphi case. Flora, Indiana for the Flora 4 case. The Flora 4 case, if you haven't heard about it, it is about 4 dead black girls who were burnt alive. It is in the same county as Delphi. And it was this November, it's 10 years ago. And nobody in law enforcement or the district attorney's office in Carroll County, Indiana, cares. I care. So, folks, tomorrow, it's Friday. Friday, I will be presenting more things about the Delphi and the Flora case. Friday afternoon, as per all as always, it is the Slightly Buzzed show. I will gather guests and we will talk about Delphi. Everybody, thank you. Thank you for being here. Thank you for the support. Give the thumbs up. And yeah, I'll see you back here tomorrow. You all have a good one. And remember, folks, hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Thank you. Bye-bye.
Santa Claus, riding in with the winter laws. Santa